Today is September 10th, 2020. Welcome to the Massachusetts Appeals Court. My name is Amy Blake. With me is Justice Gregory Massing and Justice Eric Neyman. We are your panel for today's hearing. We will be hearing 6 cases. We will take a break after the 3rd case. For those of you that may be watching on our YouTube channel, you don't need to sign out. We will be back shortly after the break. And with that, I think we will go ahead and get started with our first case, which is Commonwealth versus FABIAN Yano, docket 19P 490. Attorney Miles, when you're ready.
Thank you, Honors. Good morning. May it please the court, Mary Sita Miles for the defendant, appellant FABIAN Yano. The defendant makes 2 arguments on appeal. First, the defendant argues that his conviction for assault and battery with a deadly weapon should be reversed, where the detective was allowed to testify substantively to the recitation of events that were not part of the declarant's identification of the defendant as a person who threw the trash can. Initially, Detective McIsaac appropriately testified that the declarant, Jalea, identifies someone matching the defendant's description as a person who threw the trash can. However, whether or not that trash can actually hit anybody was not part of her identification, and under Martinez and Adams should not have been admitted. I would say that it's important to note that in the Martinez case at 175 note 6, the SJC says that while out-of-court identifications are generally preferable to in-court IDs due to fading memories, the same does not exist for a witness's description of events. To indicate how the action of the table supposedly striking the victim is not inextricably linked to her identification of the defendant, I would think it's interesting to point to this court to the way the prosecutor introduced that evidence.
Can I interrupt you? I'm sorry.
Please, go ahead.
Where do you come up with the phrase inextricably linked?
The Commonwealth uses it quite frequently in their brief. That's where I come.
But where does that come from, our case law at all, or you're just parroting the Commonwealth's brief?
I'm not sure if it comes from the case law. I can't answer that. I just know that the Commonwealth used that quite frequently in their brief.
But the reason I ask is because the Adams case, which you cite to, says at page 772, this common law rule does not render a witness's entire statement admissible, but only so much as comprises, and I think this is the key language, relevant evidence on the issue of identification. Would you agree that that is the correct standard?
Absolutely. I absolutely agree that is the correct standard.
Okay.
I think in this case, the context to give, I think Adams and Conductly and its progeny all make clear that in order for a description or identification to be relevant, it has to have some conduct. He pushed me, he did this, she did that. There has to be some context, obviously. I would say, given the testimony, given Jalea's description of the defendant, the context needed for that identification was that a metal table was thrown. Whether or not that,
or that the defendant threw the table, the guy with the braids threw the table.
Correct. So that I would say that would be the context that would be necessary to give for the identification to be relevant and to give the jury some context. Whether or not that table struck anybody is not relevant and is not necessary. I think it's important. So when the
why again, where do you come up with the term necessary? Does our case law say what is necessary or just what is relevant evidence on the issue of identification?
Correct. I think you're correct, Your Honor. I think what is relevant and what is relevant to give the identification context. You're right.
So with that in mind, when Jalea, when Detective McIsaac states that Jalea said, "I do know the boy with the braids hit him with a shelf for sure." Isn't that an expression of certainty that is relevant to the issue of identification?
Are you referring to when she is talking about her mother's culpability after she's already identified the defendant?
I'm referring to trial transcript volume 9, page 87, where Jalea was first asked, and as far as you know, were you able to identify a particular person, say that's the person who threw it? She said no.
Mm-hmm.
And then I'm referring to the statement Detective Isaac made or testified to regarding her statement to him, which is, "I do know the boy with the braids hit him with a shelf for sure."
So as part of the appendix that I gave to this court, Julia's interview was included. In her interview, she initially says, when she's talking about what was going on in the hallway, Julia says, someone with the braids, the Spanish kid with braids, no hat, threw a table. The detective then asks her, did it hit anybody? And she says, no, I'm not sure. I just knew it was thrown into the crowd. That testimony that Detective McIsaac gave was referring to the statement that was given by Julia while she was discussing with Detective McIsaac her mother's culpability with sticks and shoes and whether or not she was throwing them at the victim. So I would say that statement isn't relevant to any identification of the defendant. What was relevant that she had previously identified the defendant as someone who threw the table.
So you seem to be sort of making an argument that once any form of an identification is made, whether it's ambiguous or not, certain or not, that later on a subsequent further identification or a clarification or less ambiguous statement is not admissible.
I think the converse of that would be that I think under Conduct Lee and its progeny, important that the usefulness of having a third party testify to a declarant's identification is because the identification given in that present time is generally more reliable. It's and there might not be any intimidation, etc. So her identification of the Spanish kid with braids would therefore be more reliable, thus under Conduct Lee and its progeny, why it should be admitted substantively. But the courts have been very clear to say that any accusations or anything not relevant to that precise identification should not be admitted as substantively. So I would say that even that her saying, oh, the kids with braids definitely hit him with this shell for sure, isn't really an identification. He's already been identified. She was not being questioned about the identity of the person who threw that table. She was being questioned about her mother, and then she just spurted that out. So I would say that in that statement perhaps is less reliable than her previous actual identification of the defendant.
Isn't that really a jury question, the reliability? I mean, we don't know her tone of voice, the manner in which she said it, whether she said it with certainty or said it with hesitation. So how can we say that one statement is more reliable than the next?
Well, I think it would have been admitted as impeachment evidence. I mean, it's clear she could have been impeached with that testimony. She said she could have been, the prosecutor have asked her, did you say that at this interview, did it actually strike someone? And then it would have been a question for the jury. But to have it admitted substantively when she testified at trial that, no, I did not say that, I think is under different footing than allowing an identification and the context in which the identification was made to make it relevant and to the jury is on different footing.
Am I correct that the only evidence that the metal object or table or whatever it was or stand hit the victim was the hearsay, was the identification statement that McIsaac related? There's no other evidence that it hit it. So that the jury has to substantially rely on not the identification, but the statement that it hit him for this conviction to stand.
Correct. Yes, correct. And I think that's really important. So in the way, if you're looking, unfortunately, I have Detective McIsaac's testimony on page 84, volume 9, when the prosecutor's asking Detective McIsaac about this statement, the prosecutor's not asking the detective about the identification of someone who threw the table. She's asking about the accusation. She says, how did you find out about this table? He says, Julia. Then she says,
Sorry, where are you?
It's at volume 9.
Oh, no, not volume 9. I'm sorry, Your Honors. It should be volume 12. Volume 12. I'm very sorry, Your Honors. Volume 12, 107. I'm very sorry. So at 107, she says, when did you first learn about this information? And he said from Jalea regarding the table. And then the prosecutor asked, now, when she told you about the metal stand or shelf being thrown, did she indicate whether or not it struck anyone? And he said, yes. And then it was only then that the prosecutor asked about a description. I would say that that's pretty indicative of the fact that the prosecutor's aware that whether or not that table hit anyone was really not relevant or not relevant or necessary to give context to her identification of the defendant or the Spanish kid with braids who threw the table.
But if there are a number of combatants, as I understand what transpired here, you do have to sort of peel out each person and figure out who's who and who did what, right? He
Correct.
wasn't the only person in this melee.
No.
So what should the prosecutor have done? Could they ask any of it?
What should the prosecutor have done in terms of finding out who threw the table?
Right.
Well, then I think the prosecutor the prosecutor should have said, well, how did you find out about the table? Well, the table was, Jalea told me, well, who did she say threw the table? The kid with braids. And then I would say at that point, whether or not the table struck anyone, it's my position that that's not necessary or relevant to give context to that identification.
So that Q&A would have been permissible under your view?
As well, I mean, as long as that statement that the metal table struck the victim, no, yes, I think as long as the detective said, yes, Jalea told me about it, yes, the Spanish kid with the braids. But at that point, I'm not even sure what relevance it would give, except for maybe the murder charge to, give some sort of context as to what was going on in the hallway. But he was acquitted of the murder charge anyways. So that's the defendants in my position on that.
I know you have about 3.5 minutes left. Did you want to address your second topic?
Just quickly, Your Honors, I would just say that the Commonwealth failed to prove that the defendant intended to mislead the officers during his interview. He was clear during his entire interview that there was a ruckus and a melee going on in the hallway. He was clear that there were multiple participants in there. So the detectives and everyone involved in the investigation was aware that, people were in there. They weren't in a different position. I would say his statements that he went upstairs to get his keys and get his stuff was more of an exculpation of liability than a misdirection or trying to send them the detectives in a, misdirection as to what occurred in that hallway.
Did he materially misrepresent his whereabouts during this incident?
He said he was upstairs. Yes, he said he had to get through the crowd and he was waiting for the elevator and he was upstairs when the gunshots went off. I would say that coupled
So other than not being there, he put himself as far away as possible from the shooting.
that is correct. I would
And
say
that was not meant to mislead the police.
well, I would
Did
say
to help them?
No, he's not. I don't necessarily know if he's trying to not help them, but I don't think he's trying to mislead them in a different direction to, inculpate somebody else or something. Towards the end of his interview, the detectives asked him, we have video of the hallway. We are going to see what happens. Is your story going to line up? And he says, that's fine. I'm being honest, Your Honors. I'm being honest, detectives. That's fine. This is different than the Paquette situation where that defendant had made clear to other participants in that fight that, hey, don't tell people that I'm here, or you were at my house. I want totally out of this. So I say that would be a distinguishing factor. It would be more on the line with, I would argue, more in so much that he was just trying to exculpate himself from what happened in there and not trying to send the detectives, as the case law says, on a wild goose chase.
Is Paquette the controlling case on this issue?
I think Paquette, Morse would be the control, and Figueroa and that whole line of cases under 13B would be the controlling precedent. Yeah, absolutely.
Thank you.
And if there's no other questions, I'll rest on my brief.
Let me just check with the panel.
Good.
All right, seeing none. Thank you, Attorney
Honor.
Myers. Attorney Armstrong, when you're ready. It's just, there we go.
Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. Before I begin, I would like to acknowledge a few folks who are watching via the live stream. First, I would like to acknowledge the victim's father, in this case, Mr. Andrew Burton Sr., as well as the trial prosecutors, Assistant District Attorney Tara Birdman and Michael Glennon, who are all watching via the live stream. Your Honors, this court should affirm the defendant's conviction for assault and battery with a dangerous weapon, specifically the metal stand, as well as the defendant's conviction for misleading the police. Turning to the first issue, the Commonwealth followed the appropriate procedure under Herndon to allow Detective McIsaac to testify substantively about Jalea Antoine's identification. With regard to the substance of that identification, Detective McIsaac was properly allowed to get into the substance of that. Justice Neyman, as I pointed out in my brief, it is the Commonwealth's opinion that that identification and the defendant's actions are inextricably linked and cannot be parsed the way the defendant is asking that they be parsed. And my word choice on that.
Can't you parse them and say that there's who threw the chair as opposed to what happened after the chair was propelled through the air?
I don't believe so, Your Honor, because consider if Jalea Antoine had said, before she identifies the defendant as the Hispanic male with braids, consider her explanation of being in the hallway and saying the table hit the victim. And then she continues to say the table was thrown by the Spanish kid with braids with no hat. And then she says again, the Spanish kid with braids and no hat was at the party. You wouldn't disassociate the kind of conclusion of the action, the table hitting the victim, if it had come before. And even more, the table hitting the victim.
Well, why that doesn't make any sense. If the question is it has to be identification, why are you even talking about what happened to the table?
Because it's a relevance question. So were the defendants...
In fact, as Attorney Miles pointed out, the way this starts is McIsaac, the first thing they say is not who was it, but during your interview with Ms. Antoine, did she indicate whether it struck anyone? Doesn't say, it doesn't ask who. It said, did it strike anybody? Because that's a missing piece of evidence. Yeah.
I would, excuse me, I didn't mean to interrupt.
Go ahead, no, go ahead.
I would actually disagree that that is the only piece of evidence, because if you review the sufficiency of the ABDW metal stand, if you look to Jalea's cross-examination, specifically transcript volume 9, page 84, on cross-examination, the defendant's counsel asks, and where was the table thrown? Like it was closer to the crowd. And were you able to see if it hit anyone? No, I assume it hit everybody. So that statement there, in the light most favorable to the Commonwealth, could allow a jury to believe that the table struck everyone in the hallway, including the victim.
Attorney Armstrong, I'm sorry to do this to you, but I want to make sure, Attorney Miles, that you're still with us because we lost your video. Okay.
I'm still here. I just, for distraction's sake, I wanted to stop.
Okay, if you could keep your video on so that we know that you're here. And Attorney Armstrong, if you need a couple of minutes for my interruption,
Sorry.
I will certainly give that to you. Please continue. I'm so sorry.
That's fine. Thank you, Your Honor. So Justice Massing, I would disagree that the only piece of evidence is...
Okay. So that goes to prejudice more than whether they're there or not. You'd say it's...
Sure. Correct. And I would still say there is no error in Detective McIsaac's testimony, because the explanation about the table striking the victim was completely relevant as a whole to Jalea's initial identification of the defendant throwing the table which struck the victim.
Well, I mean, I've got Commonwealth versus Walker open in front of me, and it discusses the Martinez case. And we've concluded that an eyewitness's out-of-court statement identifying a defendant as the person shooting at the eyewitness's friend is part of the context, but a statement regarding the number of shots fired, the color of the firearm, and the defense behavior after goes beyond this extent of identification. Isn't this more like the number of shots fired, as opposed to who fired them?
Sure, I understand Your Honor's point, but if you're gonna parse it that thinly, then wouldn't that identifying witness not be able to say that that person had a gun? Wouldn't that person just be able to say, I saw defendant standing there with his arms outstretched? If you're gonna parse it that thinly and disassociate the identification from the actual crime, then wouldn't you have to backtrack far enough to say that identification was not of the defendant holding a gun, it was of the defendant with his arms outstretched, and then you stop right there?
When the trial judge is deciding whether or not to admit this type of evidence, what is his or her standard for doing so?
It's relevant, Your Honor, and whether or not that,
I thought it was discretion.
it would be reviewed for whether the judge abused their discretion to allow that evidence in.
Yes. And in fact, the case law has broad discretion.
It says broad
Correct.
discretion, I think under Adams at 772. So when we're dealing with this issue of whether or not the sentence can be parsed or not, or whether an expression of certainty versus a statement that is less certain is admissible, isn't that within a judge's broad discretion to determine at trial?
Precisely, Your Honor. And this was an extensively litigated issue through the defendant's motion to suppress, through the motion in limine, and then it was discussed so much so that the trial judge gave the defendant a standing objection throughout the trial, where he didn't have to stand up every time that this was brought up.
And I understand your argument about the words inextricably linked. And Attorney Miles at one point used the term necessary. But my understanding of the case law is that it does not use the words inextricably linked. It does not use the word necessary. It's whether or not it is relevant evidence on the issue of identification.
That's correct, Your Honor. I would agree with that. My perspective of choosing the words inextricably linked is to highlight how Jalia's identification was more than relevant. And the circumstances around the identification and the defendant's actions were above that low bar of relevance. And if there's no further questions on Detective McIsaac's testimony, I'll use the remainder of my time on the misleading the police.
Go right ahead.
Thank you. So this court should affirm the defendant's convictions for misleading the police. And in doing so, it's important to remember the standard of review of this. We're looking at the sufficiency of the evidence and whether or not that evidence, in the light most favorable to the Commonwealth, with all reasonable inferences drawn in the Commonwealth's favor, any rational trier of fact would find that the defendant's statements reasonably could lead investigators to pursue a course of investigation materially different from the course they otherwise would have pursued. I think and that language is from Paquette. And the most important word in that language is whether the defendant's statements reasonably could. The defendant's statements don't have to send the police in a materially different direction. And in fact, if a defendant lies to exculpate himself and the police continue their investigation and charges result based on, the defendant's conduct, that is sufficient for a conviction of misleading the police. And I would point your honors to Figueroa, where the defendant in Figueroa was on a parole, conditions of release post state prison term. He had specific parole conditions, including not to go around children under the age of 18 in areas where they congregate, and not to begin a new romantic relationship with someone who has children under the age of 18 without permission from the parole officer. And specifically in what led to the charge in that case was on the night of Halloween, Figueroa's parole officer said, do not go anywhere where there will be young children out trick-or-treating. It was more than that. It said, do not leave your home. So when the parole officer the next morning checked the defendant's GPS bracelet and saw that pings were outside of the defendant's home, specifically in an apartment complex in Framingham, the parole officer called Mr. Figueroa and said, can you explain to me why your GPS ping went off in Framingham? And Mr. Figueroa said, I was at an AA meeting and there must have been a glitch in my GPS system. In that moment, the parole officer was skeptical about his explanation, continued to do investigation, and ended up finding out that Mr. Figueroa was actually with a new girlfriend with her children under the age of 18. It was out trick-or-treating. That, even though the defendant's exculpatory statement did not mislead the parole officer, that's a question for the jury. And the jury in that case found that statement, that solely exculpatory statement, was sufficient to show that the defendant had the intent to mislead, and he actually did mislead the parole officer.
Do you agree with Attorney Miles that Paquette and Morse are the leading cases, or rather the controlling cases on this issue?
I do, yes. And I would even compare the facts of Paquette to the facts of this case here, where the police officers asked Mr. Paquette, and I'm focusing in Paquette on the first interview, the conviction that the SJC said could have been affirmed if the jury were instructed correctly. The police asked the defendant where he was at the time the fight broke out. In his house. He said, I was outside, I was picking up beer cans, I heard a ruckus, I went inside, everyone had dispersed. That's almost identical to what you have here, except instead of someone having a bottle smashed over their face, there is an individual dead with 2 gunshot wounds to his chest. And here, the defendant has completely exculpated himself from all involvement. In fact, he tries to paint the picture as him being him trying to de-escalate the situation by pulling his little brothers out, by protecting his family, and tries to actually shift the blame to the victim who's lying on the ground and saying, you know, that guy was acting crazy. He had a knife. He was swinging at people. I was trying to de-escalate the situation. And then when asked if he heard a gunshot, he says, oh no, I was upstairs. So if you look at it from that perspective, that is even stronger than Figueroa, where Mr. Figueroa was simply exculpating himself. Well, here, the defendant was not only exculpating himself, but providing exculpatory information about his alleged family, the people who he was at the party with. And then I would compare that fact to the Fortuna case, where a shooting victim who was interviewed by police 2 separate times, told those police, I was shot at close range. I didn't know who the guy was. I couldn't see who he was. He got into a car and drove off. That was one version. The second version was he said he was shot from far away. And based on the detective's forensic understanding and his experience as a police officer, and then the forensic expert's testimony at trial, the shots were actually from no more than 18 inches away. So that shooting victim's explanation and answer to those questions wasn't exculpatory to himself. In fact, he was trying to disassociate the shooter of this crime. So when you look at the facts of Fortuna, the facts of Figueroa under the lens of Paquette, I would say that the defendant's interview, which happened a few hours after the homicide, where the state of police knowledge is minimal at best, that is sufficient for a jury to conclude that the defendant had the intent to mislead police.
Does the panel have any additional questions? Mr. Armstrong, if you have exhausted your arguments, we certainly can end early, and you can rest on your brief for your remaining arguments.
Certainly, Your Honor, I have nothing more to add. Thank you very much.
Excellent job from both attorneys. The matter will be deemed submitted. Thank you both very, very much.
And we are live.
Wonderful. The next case this morning is Commonwealth versus, and I apologize if I mispronounced this, ALIDIO Barbosa, docket number 19P1015. Mr. Griffiths, when you're ready.
Thank you, Your Honor. May it please the court, Darren Griffiths for ALIDIO Barbosa. Your Honor, this is really a case as to whether or not the Commonwealth met its burden, both at the trial and in the motion to suppress hearing, to establish reasonable suspicion for the stop and seizure of João Fernandes. As to the armed career criminal conviction, in Resendez, this court made it plain that the legislature drew a distinction between a deadly weapon and a dangerous weapon for purposes of juvenile adjudications under the Armed Career Criminal Act. As this court noted in Resendez, had the legislature intended for the Armed Career Criminal Act to apply to all juvenile adjudications involving dangerous weapons, it could have used the term dangerous weapon rather than deadly weapon. The words deadly and dangerous do not have the same meaning under ordinary usage. What's deadly is patently also dangerous, but it does not follow that what is dangerous is necessarily deadly.
What was the weapon in Resendez?
The weapon in Resendez was a pen, Your Honor.
And was the holding that a pen could never be a deadly weapon, or was it that there needed to be evidence as to how the pen needed to be used in a particular case to be a predicate for an armed career criminal conviction?
I think the holding was that the pen was not an inherently deadly weapon. I don't think they got into an inquiry about how it was used in the particular case. I think the holding was merely that the pen did not qualify as a deadly weapon and therefore could not be a predicate offense that qualified under the Armed Career Criminal Act.
Well, let's assume that the pen in Resendez had been used to stab someone and it actually went deep and pierced through an organ in that case. Do you think it's likely that the court would have ruled that it was a deadly weapon under those circumstances?
I don't think so. I think it comes down to a definition of what is inherently dangerous, and I think there has to be. I think the reason that the legislature drew that distinction was because they were trying to limit the application of the Armed Career Criminal Act and juvenile adjudications under the Armed Career Criminal Act to only inherently dangerous weapons. And so
I'm sorry to interrupt you, but just to distill this a little more quickly, is your argument that an unloaded gun can never be categorized as a deadly weapon in this context as a matter of law?
I think, I guess I would frame it a little differently. I think it's the Commonwealth's burden to establish.
Can you answer my question first and then reframe the question?
Okay. So
question again is your argument, or does your argument hinge on the notion that an unloaded gun cannot be categorized as a deadly weapon as a matter of law in the context of a predicate conviction for the armed career criminal conviction?
So I think my argument doesn't hinge on whether or not an unloaded weapon could ever be a deadly weapon or classified as a deadly weapon. I think the argument here more hinges on whether or not the Commonwealth met its burden in establishing that the gun that was allegedly used in the assault with a dangerous weapon in this case was actually a operable firearm that could be considered a deadly weapon. There was no proof.
Well, didn't your client plead guilty that that was in fact the case?
So there is no evidence of what he pled guilty to an assault with a dangerous weapon. And there was evidence regarding what the allegations were, but there was no evidence actually to what he actually pled to that was introduced.
But wasn't the plea contingent upon a reduction from a charge of armed robbery to ADW?
I'm not aware that it was, Your Honor. I don't believe there was a robbery that was alleged actually in the underlying case. I think the allegation was that he allegedly pointed a gun at people in traffic. I don't think there was ever an alleged robbery in this particular case. And there was no gun recovered in this case. There was no evidence that it was ever operable, and there was no evidence that it was actually a gun at all. It could have been a BB gun that he was pleading to. It could have been a toy gun. There's simply no evidence that was introduced indicating that the gun that was alleged to have been used in this assault with a dangerous weapon was actually a deadly weapon. And
Well,
that is necessary.
do you dispute that Officer Ross testified at transcript 1112 that the defendant threatened two strangers at gunpoint? That was the factual basis for the plea to assault dangerous weapon?
So I don't know that we know that that was the factual basis for the plea. That we know that that was what was alleged originally. We don't actually know what was stated in the plea or what was indicated in the colloquy with the defendant when he was adjudicated delinquent. That's not what was introduced at the trial. What was introduced at the trial were the allegations that that Mr. Barbosa waved a gun or threatened people in traffic with a gun. Those are the allegations. It's not clear what was actually pled to during the colloquy. And I think that is important because it is very possible that Mr. Barbosa understood that he was pleading to an assault with a dangerous weapon, like a BB gun or some other type of like toy gun, and that he did not understand that he was pleading to an assault with a deadly weapon, that he was pleading to a charge involving an operable loaded firearm.
Well, there's no ineffective assistance claim here, right? As to what he knew or didn't know about that plea?
There is no ineffective assistance claim, Your Honor. No, there is not. I do think that counsel did not initially raise this issue of whether or not the Commonwealth was required to enter proof of the fact that the gun was deadly, or the weapon was deadly rather. But after the Commonwealth made their argument, there was rebuttal argument from trial counsel that I do think did raise this issue and preserved it. So I do think there was some question as to whether or not this particular offense qualified that was raised by counsel after, I think, basically he realized that the Commonwealth was addressing it and he needed to do so as well.
I'm still a little confused on the question of a law versus question of fact thing. There's clearly evidence that he pled guilty to assault with a dangerous weapon, which is not the same thing as a deadly weapon. So is the Commonwealth allowed to introduce additional evidence to show that it was in fact a deadly weapon?
I think they're required to, actually, Your Honor. I think.
Yeah. So we don't look at just the elements. We can actually look at as the crime actually was committed.
I think that's required. I think that the Resenda's decision makes clear that the fact that the weapon was actually deadly is an element of the offense, of the armed career criminal offense. And for that reason, I think you have to introduce evidence that the weapon was actually deadly. And I think the Commonwealth tries to skirt around this issue by saying that you can sort of make reasonable inferences in order to establish or to conclude that the Commonwealth met its burden in this particular case. But you cannot use reasonable inferences to overcome the fact that the Commonwealth did not meet its actual burden of proof to establish that the weapon that was actually used in this particular case was a deadly weapon. And that
I just have one more question on this issue. Are you familiar with the cases that state that a toy gun or an inoperable gun can suffice to be a dangerous weapon in the context of assault dangerous weapon conviction or for an armed robbery conviction?
I am, yes.
Do those cases have any applicability to this situation, and why or why not?
Well, I think certainly in some contexts, a toy gun or an inoperable gun can be a dangerous weapon, but I think it's very clear that a dangerous weapon does not qualify as a deadly weapon. That is something that is mortal or lethal or fatal or deathly. And I think in those cases, I guess the factual distinction between deathly and dangerous is very important, and it sort of controls. There's a different application, I think, just basically that the term is different and it has to be applied differently in these different contexts. Turning to sufficiency question, the defendant's conviction in this case required the jury to pile inferences upon inferences to reach a verdict. The only
Can
evidence.
I ask you, what do you think the video shows?
I think it's
In the light
inherently-
most favorable to the Commonwealth.
I think even in the light most favorable to the Commonwealth, Your Honor, all of the video shows that an object was passed from the defendant to Mr. Fernandez. That is the best you can get from the light most favorable to the Commonwealth. And I think beyond that is pure speculation. Going beyond that and saying that the gun or that the object was even gun-shaped or that it was in fact a gun is just speculation. You cannot tell from that video. And I have watched it more times than I care to recount at this point. It's just, you cannot reach that conclusion. And I think the jury had to engage in speculation to reach that conclusion. It was equally as likely that the weapon or the object rather that was passed was some other object, including potentially the ski mask that was found in the same area of Mr. Fernandez's body when he was searched during the booking process.
Is it equally likely, I'm sorry to interrupt, but is it equally likely when the one defendant was seen walking into the pizza shop, walked out 4 seconds later, and walks down the street, and then the next defendant comes out and he's looking around inside the pizza shop and then walks out and immediately starts sprinting down the street? Doesn't that at least slightly suggest that maybe it was something more than an innocuous object that was passed?
I think the surrounding context around that, Mr. Barbosa's, suddenly leaving the pizza shop is also important, because it's equally as likely that he got a call from someone on his cell phone. After he enters the pizza shop, you can see him talking on his cell phone. That he initially approaches the counter, engages in some conversation, and then you see him start talking on his cell phone, and then gradually sort of, it seems like, gains some urgency, I would say, regarding whatever he's hearing on that conversation, and then leaves the pizza shop in a hurry. So there are equally plausible reasons that he left the pizza shop, that it doesn't necessarily equate to a consciousness of guilt. And I think, given the full context, again, the jury was just left to speculate. And that, I think, is clear from the case law, that a jury's verdict cannot be based on speculation, that it can't be based on these sort of equally plausible explanations, that you do need proof beyond a reasonable doubt.
But what if the jury concluded that what was passed was the gun or firearm?
I just think that the only evidence of any object being passed was too inconclusive for a reasonable jury to draw that conclusion. And I think all of the circumstantial support for that is equally plausible, that all of the surrounding circumstances support a different conclusion, support a conclusion that that Mr. Fernandez was not passed a gun, that he was passed another object.
Well, let me ask you this. In analyzing this sufficiency question, we can look at, in light most favorable, the video that we just talked about, the defendant's flight, that Fernandez, shortly after this exchange, did, I think they call it some kind of a security check. Moments later, a gun was found in his waistband, and ammunition in your client's bedroom was also found. So I get why you want to parse each piece, but don't we look at the whole picture and in the light most favorable?
Yeah, I think you do, but I think even if you look at, for example, the again, I'll leave the video of the exchange aside, and the flight from the pizza shop aside. Even if you look at the evidence in the light most favorable to the Commonwealth regarding the exchange between Mr. Fernandez and that individual he passed on the sidewalk, I don't think that evidence actually supports the Commonwealth's conclusion, or the Commonwealth's contention, the officer's contention at trial, that Mr. Fernandez did a security check. I think the video is actually pretty clear on that particular point. That
Actually,
Mr. Fernandez,
I do want to ask you about that. And with respect to the motion to suppress now, the judge finds, with respect to the motion to suppress, based on the testimony of the officer, after nearly bumping into another man coming towards him, Fernandez did a security check, reaching to the right side of his waistband. What is your base for saying that that's a clearly erroneous finding?
So I think it's purely based on a review of the video. I think if you look at the video is pretty clear that what happens there is not that he bumps into a person. It's pretty clear that he reaches over with his right hand and gives a dap or a greeting to the person who's walking by him, who he seems to know. And that then he reaches back with his right hand and continues on. And you can see his hands by his side, that they are not actually going to his waist to perform a security check, but the only reason he reached over to his right side was to greet the person who was walking by him. I think. But
what happened after that? We're seeing him from the back. What happened after that?
Well, I think the testimony of the officer is basically that the security check happened immediately, either before or after he allegedly bumped into this person, which didn't happen on the street.
Okay, we'll have to look at I'll look at the transcript for that. Thank you.
I know the time has expired. Justice Neyman, do you have any additional questions?
With the panel chief's permission, I do have one more.
Of course, of course.
Mr. Griffiths, on the issue of automatic standing, are you familiar with the case of Commonwealth versus Carter?
I'm not. I don't believe I came across that case in my review.
Okay, it's a case that sort of involves the distinction between automatic standing and reasonable expectation of privacy, but we can save that question for another day then.
I guess, if I could just address the question of automatic standing, I think really turns on the question of possession, right? That when the question is whether or not there was possession of certain seized evidence at a time of a contested search, that's when automatic standing confers. And I think possession implies control and power, exclusive or joint, or in the case of constructive possession, knowledge coupled with the ability and intention to exercise dominion and control. And I think there's no question that this case came down to possession and possession of evidence that was the subject of the motion to suppress hearing. And I would say that I think it's clear that Amendola and the cases that come after Amendola indicate that this is should be a case-by-case determination as to whether or not automatic standing applies. The question of possession was central to the motion to suppress hearing. It was central to this case. And I do think automatic standing should apply. And I think the question of whether or not the defendant had an expectation of privacy in the groin area or the waistband of Mr. Fernandez, the Commonwealth did not raise that issue below. And I do think because they did not raise that issue below, I do believe that it's waived at this point. I don't think they can now argue that on appeal. Thank you.
If the panel doesn't have any other questions, we will move to Mr. Wakeford, and we gave your brother an additional 3 minutes. So if you need those, we will also give that to you. So when you are ready.
Thank you, Justice Blake. Good morning. May it please the court. I'm representing the Commonwealth in this case. My name is Donald Wakeford. And I suppose I'll begin by saying that the defendant's conviction and the judge's order denying the defendant's motion to suppress should both be affirmed because the video evidence in the case and the reasonable inferences that one can draw from viewing that video, which the justices have sort of gone into a little bit while my colleague was arguing, allow the conclusion to stand that what was passed was a firearm. And that supports the jury's verdict. And the findings of the judge in denying the motion to suppress are also supported by the video evidence in this case and the unrebutted, credited testimony of the officers at the motion to suppress. I believe this court should affirm both the verdict and the judge's ruling because the evidence is pretty clear.
So do you think that you can see a gun being passed, or do you think that there was an exchange and the jury could draw the inference that it was a gun?
It is certainly very quick. I'll actually borrow the language used by the motion judge in a footnote in the order denying the motion to suppress, which is that it is a dark gun-shaped object. and that the video allows one to draw the inference that what was passed from the defendant to Fernandez was the gun-shaped object was in fact a gun. I think that all of the circumstances which have actually sort of been gone into, including the fact that the defendant waited a few seconds before fleeing from the location on a broken foot, support the inference that what was passed was a gun and not an innocuous object. I certainly believe that when you look at this evidence in the light most favorable to the Commonwealth, when we're talking about whether the jury's verdict was supported by the evidence, certainly viewing the evidence in that light, that inference, that conclusion is supported by the video evidence and the attendant circumstances around it. And drawing the conclusion that it's rank speculation or that it is an impermissible conclusion actually throws the correct standard out the window and actually views the evidence not just in the light most favorable to the defendant, but in the light unreasonably in favor of the defendant. Quite frankly, there is no sequence of events which makes sense here, except that a gun was passed because Mr. Fernandez was apprehended mere moments later with a gun in the exact location that we saw the object be placed. So I believe that the evidence together with the inferences which we draw in the light most favorable to the Commonwealth make it quite clear that the jury's verdict was supported in this case.
Could you address the armed career criminal? And that's a kind of a complex issue.
It is certainly one where we have to, where certainly the defendant would have us draw some fine distinctions. The Commonwealth's position, which we actually defend in our brief, is that the court does not have to draw this distinction, and as actually the appeals court has actually declined explicitly to draw this conclusion, actually in the case of Resendez. I believe it is in footnote 7 of Resendez, where the court states that guns are both dangerous and deadly. So the distinction does not have to be drawn between the two of them. Obviously, the distinction between dangerous and deadly can be of interest when the object in question is something like a pen or something that can become dangerous or deadly depending on circumstances. However, I believe it is in Foreman that which is 63 Massachusetts Appeals Court 801, a 2005 case, where this court said that it does not believe that the legislature's intent was to have the appeals court drawing distinctions between types of guns, such as a deadly shotgun versus a non-deadly shotgun, and what the defendant is asking us to do here is draw exactly that distinction with regard to whether an unloaded or loaded gun is dangerous or deadly.
Yeah, so let's assume a gun is a gun. The defendant didn't plead guilty to assault with a gun. He pled guilty to assault with a dangerous weapon.
Yes.
So how do we make the leap that he committed a crime that involved the use or threatened use of a firearm?
Well, again, here we're dealing with a standard where, this is a factual question, I believe, and so we're looking at the evidence in the light most favorable to the Commonwealth, whether the judge at the jury-waived ACC trial could reach the conclusion that Your Honor is talking about. And I believe that because not just the docket showing the defendant's plea as a juvenile to delinquency on this charge, but also the testimony of the arresting officer, who stated that he talked to multiple witnesses who said the defendant was weaving through traffic and pointing a gun at them as he did so. No firearm was recovered in the case, but the evidence that the judge in this case received in the ACC trial was that the arresting officer had evidence that a gun had been pointed at multiple people, and then with the docket, evidence that the defendant had allowed himself to be adjudicated delinquent on a charge of assault with a dangerous weapon, to wit, a gun. That's about how I believe it was charged: assault with a dangerous weapon, to wit, a gun. So all of this together just shows us that we can take the leap, I suppose, but I think what it really shows is that viewing the evidence in the light most favorable to the Commonwealth, the docket plus the police officer's testimony support the decision reached by the judge that the defendant actually pointed a gun, which is both deadly and dangerous.
You just argued a moment ago that there's some sort of a limiting principle, I think, in Resendez that it only applies to, I guess, what you would call inherently non-deadly weapons, such as a pen. But the word chosen by the court, among other words, of weapons that are inherently deadly, were loaded weapons. That's what it says in footnote 14 of Resendez. So what do we take from that?
Well, certainly the defendant would have you draw the distinction that that implies that non-loaded weapons or unloaded weapons, pardon me, are not deadly. I do not believe that the court intended to create a distinction of this kind by placing it in a footnote in Resendez. I think Resendez was much more interested in the question of dangerous and deadly with non-traditional weapons, and that certain things are obviously deadly, a loaded gun being one of those things. I think that when you read Resendez in combination, obviously the use of loaded gun permits the argument that the defendant is making, but when you read Resendez in combination with the language in Foreman, it says clearly that guns are both dangerous and deadly. And in fact, in the same footnote where
Did Foreman
in Resendez, where
did Foreman distinguish between loaded and unloaded guns?
nothing has ever distinguished between loaded and unloaded guns, Justice Neyman, not to my knowledge. And in fact, in the same footnote, footnote 7, where this court stated that dangerous and deadly apply to guns in all cases, they actually cite the 2 cases, one of which is Williams. And Williams was a case of assault where there was no evidence that the gun was loaded. So I believe that just reading Resendez itself, it indicates that they're looking whether it was a gun involved that suffices under ACC.
Mr. Wakeford, on page 21 of your brief, you say that the Commonwealth's evidence suffice to prove that the defendant's prior adjudication of delinquency by reason of armed robbery met this definition. Where does that armed robbery piece come from?
Yes, Your Honor. I apologize. That was actually the subject of a correction in the defendant's reply brief, where it was noted that that was a misstatement of fact. That was simply an error on my part.
There was not an armed robbery. There was, as we have the record now, perhaps a gun pointed at 2 strangers.
Yes, Your Honor, and it was an assault with a dangerous weapon. That was what the adjudication was. So I apologize to this court for the misstatement of fact. That was highlighted by the defendant's reply brief, and I never saw fit to contest it because that was simply an error on my part.
Thank you.
Apologies.
Skipping around a little here, and I guess this is relevant on the standing issue, but was the Commonwealth's position ever that the defendant that the defendant possessed the gun in Fernandez's pants, or was it that he possessed the gun previously?
The Commonwealth's argued and stated position has consistently been that the defendant actually possessed the firearm inside the pizza shop before passing it to Mr. Fernandez. The Commonwealth's theory of the case was not constructive or joint possession. Now, I will state to this court, in the interest of not trying to hide the ball, that the trial judge charged the jury on all forms of possession. But start to finish, including at the motion to suppress, the Commonwealth's case has been actual possession before it was passed inside the pizza parlor. And this is actually referenced in the motion judge's order denying the motion to suppress, where it says that the Commonwealth maintains that this is a case of actual possession and that the defendant does not have standing. The motion judge, of course, found that they did not have to decide that issue because there was adequate evidence to show that it was not an illegal search and seizure. So, but the Commonwealth's position the entire time has been that this is a case of actual possession, and we believe that the video backs that up entirely. So the issue of standing is one that we believe, frankly, there are policy questions which can be asked, but frankly, the state of the law indicates that you have to have either an expectation of privacy in the place that was searched, an interest in the place searched, or a presence at the time that the object was seized. One of those 3 things is what establishes automatic standing. And in fact, in I believe trying to find the citation. Oh, pardon me, Amendola, the SJC indicated that these cases are going to be about vehicles and houses and very rarely be expanded past that. I think the Commonwealth's position is simply that in this case, you would have to find that the defendant had an interest in another person's person, frankly, the contents of their pants, and that automatic standing is not intended to extend so far, particularly where the defendant took great pains to remove himself from the immediate vicinity as quickly as he could. However, it is not crucial, it is not necessary that this court decide that issue because as the motion judge took great pains to point out, there was ample evidence supporting reasonable suspicion and the legality of the stop in this case. So the question of standing is not necessary to be decided.
Sorry to be jumping around a bit here. A couple evidentiary questions. So there are 40 caliber bullets found in the defendant's bedroom, and the gun is a 40 caliber gun. But the bullets were admitted for a limited purpose to show the defendant's state of mind. Could you explain that to me? I don't really understand that.
I believe it is at volume 9, page 38 through 41. There's the question of the ammunition found in the defendant's bedroom, and the reason, and the judge charged the jury, gave the jury an instruction as to why this evidence was being admitted, so that it was not confused with the actual ammunition, which were the basis of charges in the case, that being the ammunition found in the weapon. The ammunition found in the defendant's bedroom was the exact form of ammunition that was found in the gun. So the Commonwealth introduced that evidence to show the defendant's knowledge that the gun was loaded. That was the reason that the evidence was introduced, and the judge actually instructed the jury as to exactly why we were hearing about this ammunition found in the defendant's bedroom. It was to show the defendant's knowledge that this was a loaded gun, because it wasn't just the same caliber of bullet. We don't have pictures because the ammunition found in the bedroom was actually introduced into evidence and allowed to go back with the jury, I believe. But they were told, not just as the same caliber, it is the exact same ammunition, the same stamp, it's the same thing. And it was intended to meet the Commonwealth's burden for knowledge.
Okay, thank you. On the defendant's last issue, he didn't get around to it, but you agree, wouldn't you, that the officers referring to being in the gang unit and saying that they recognized the defendant from before, that shouldn't have come in, but I think your argument is that's just not a substantial risk here because it wasn't associated, it didn't associate the defendant with gangs?
I think if this could be done over again, it would probably not need to come in, but this is not a substantial risk situation, Your Honor. I think, Justice Massing, we have ample case law delineating the circumstances in which this can give rise to a substantial risk of a miscarriage of justice. It's almost always cases where there are gang charges or where a gang theory of the case is central to the Commonwealth's sort of theory of the case. Neither of those are present in this case. It was one mention of recognizing the defendant. The rest of the mentions were involved with general assignments on the Boston Police Department. And
I think it would be helpful, though, to remind the trial prosecutors there's no need to go there and create an issue.
Yes, Your Honor, it's something that if it's not necessary, probably that assignment doesn't need to be mentioned. But we know in circumstances like particularly where there was no reference to gangs and no theory of the case put forward and no reference in closing argument by the trial prosecutor, that it just doesn't give rise to substantial risk of a miscarriage of justice. But yes, obviously, prosecutors should keep that in mind, Justice Blake.
So your time has expired. I do want to make sure the panel doesn't have any other questions. And I did say that you could have an additional 3 minutes if you needed it because we went over with Mr. Griffiths. So Justice Massing?
No.
Justice Neyman?
No questions.
Attorney Wakeford, anything else?
I believe I've addressed the issues that I sought to address and responded to my colleagues' arguments. Since this court has no further questions, I will rest on my brief.
Great. This was a very well argued case on both sides. Very much appreciate that. We will deem the
And we are live.
Thank you. The next case is Commonwealth versus Sandra WAWERU, also known as William, docket 20P71. Attorney DeMello, when you're ready.
Good morning, Your Honors. This case is about a case that the defendant was denied her right against self-incrimination under Article 12 by the admission of her statement that she could not complete the field sobriety test because of her shoes. Her statement about her shoes should have been excluded because it was part and parcel of her refusal to take a field sobriety test. And I think it's important to look at what the prosecutor said when he first brought up this issue to the judge. He said, quote, she indicated that she wouldn't do it, not because she didn't want to, but because of her shoes and because she was off balance. She was asked an opportunity to take off her shoes and she did not want to take off her shoes and didn't perform the test. So that's what the prosecutor said when he first raised the issue to the judge.
This was at sidebar.
And it was at sidebar, yes. And well, it wasn't at sidebar, it was actually before the trial during a motion in limine.
But outside the hearing of the jury.
Correct, Your Honor.
Okay.
This is consistent with the police report. I know the police report's not in the record, but the police report he's basically paraphrasing what the police report says there in terms of what the evidence was. So based on what the defendant actually said to the police, the comment about her shoes was part of the refusal. It shouldn't have been admitted. It should be noted also what we're talking about, what she's refusing to do is the one-leg stand test. So that's a test where she's got to balance on one leg, and what shoes she's wearing is really important with respect to whether or not she can balance.
But that never came in, did it? The one-legged test?
The fact that it was a one-leg stand test never came in, and the test itself never came in. The only thing that came in was, and this is sort of where it's a little bit unfair, the officer sort of modified what she said. The officer didn't say.
He testified that she said after the completion of the heel to toe walk and turn test that she was off balance because of her wedged shoes or sneakers.
That's what he testified to during the trial. But what the police report says and what the prosecutor's saying in his motion in limine is that she refused to do the test because she was off balance because of her shoes, refused to do the next test. So in a sense, it's almost a misrepresentation because she's not saying, I did this other test and I'm off balance because of my shoes. She's saying, I'm refusing to take the next test because I'm off balance because of my shoes.
Was there an objection on that basis at trial?
There was, when the prosecutor initially brought this up prior to trial in the motions in limine, the defendant did object. There are some portions of that conversation that are omitted, but the objection's there. And then when the prosecutor asked about this information at trial during the testimony, there was also another objection by the defendant.
It's not really clear to me what the specific objection was to. And I'm speaking specifically about trial transcript pages 54 to 56 and 115 to 117. The basis is not clear from the record, in my view, and perhaps you can correct me. And there's a number of inaudibles in the transcript. It would have been helpful to have an accurate transcript.
I agree that there's missing portions of the transcript, and specifically what the defendant states as his grounds for that objection. It's not there. But I think if you look at what the judge actually addressed, and if you look at the purpose of an objection like this is to bring an issue to the judge's attention so that he can make the correct choice. And here, when you look at what the judge actually talked about, what the judge actually decided, he's deciding whether or not this constitutes a refusal and what part of the statement constitutes a refusal. And when he makes that decision, the defendant objects, and then he objects again during the trial. So my argument would be that—
Well, he objects. I'm sorry to interrupt you, but he objects, and then he says, Judge, are we getting into, and then it's inaudible. And I'm not sure if he just wanted to object to make sure that the refusal evidence did not come in, which it did not, or was he further objecting to the shoe evidence coming in? I don't think that's clear from the transcript, but perhaps you disagree with me.
Well, in that context, during the trial, the judge responded and said, this is what we discussed before. Again, referring to the discussion that took place earlier before the trial. And I think the defense position is that it's clear from what the judge is saying that he's talking about the issue that was actually decided, that this was an issue that was looked at by the judge, considered by the judge. And again, I did this in my reply brief, but I point to the Woody case where it's not just the appellant that has a duty here, it's the appellee. If the appellee actually felt that the grounds for the objection here were something other than what was actually discussed on the record, then it's really incumbent upon them as well to make a proper record. So
I thought that the burden was on the appellant if the record is not unequivocal on the issue.
Well, again, when you look at the Woody case, in the Woody case, the defendant argued that there was insufficient evidence, but there were missing portions of the transcript. And the appellee said, well, there's missing portions of the transcript. That evidence might have been there in that missing portion. And the judge, the court in that case said, well, then the appellee should have put together the record. And here, the appellee is raising the objection that, look, the grounds for this objection aren't in the record. It's not clear from the record whether or not this was preserved, but they did nothing to try and reconstruct the record.
But let me ask you, under either standard of review, what we have is the testimony about what your client did or didn't do correctly in the walk and turn test, and then a statement that she was off balance. Certainly, what the trooper described her actions during the walk and turn test could be described as off balance. So I know you say that it misrepresents what transpired, but it seems to me that you have a test. She can't stand still to listen to the instructions. She doesn't properly follow the test. She says that she's off balance, that the problem is with her shoes. The trooper says, do you want to take your shoes off? She says no. That's the end of the testimony. We know the actual refusal to do the one-legged stand doesn't come in. And the only reference to a first test is one errant comment leading up to a question by the prosecutor, but there's never any evidence or discussion, nothing in closing argument about a first test or a second test. So I don't know how we get to that refusal evidence came in. Can you help me with that?
Sure. The defendant's position is that this statement about her shoes is part of her refusal to take the second test. She's not saying, I performed poorly on the first test because of my shoes. She's saying, I didn't want to take the second test because of my shoes. And when you actually look at
you say that's in the police report or something? You're getting that from where? Where are you getting that from?
Well, first of all, from the transcript, page 54 to 55, that's what the prosecutor said, where I read that earlier in my argument, where he's saying she's refusing not because she doesn't want to take the test, but because of her shoes. So that's what the prosecutor said. Again, it's in the police report as well, but that's not in the record, but it's consistent with what the police report says.
You agree that the specific piece of the closing that you're raising on appeal, that was not preserved, correct?
Are we talking about the second issue?
Yes, on the closing.
The misstatement in the closing was not preserved at trial. There wasn't an objection made to that specific one. The defendant's position there is that there's a substantial risk of a miscarriage of justice, given that this wasn't an overwhelming case of intoxication. There was disputed evidence. There was a witness that said that she wasn't exhibiting the signs of intoxication that the police officer said that she was exhibiting.
That was her boyfriend?
That was Nooks, her boyfriend, yes. But
So,
there's also
so the argument, I'm sorry to interrupt. The argument is that there was evidence that the defendant told police that she had 1 or 2 drinks, and the prosecutor stated in closing argument, she says she has 1 or 2 drinks. She may have had more. And you're saying that that created a substantial risk?
Well, I think we should look at what the prosecutor said precisely. He said, or she said, but she knows because she told the officer a different answer than what he said. She had at least 2. That's how much she said. She could have had more. So he's saying she had at least 2. That's not what she said. She said that she had 2. The officers
But the boyfriend said she had 1 or 2, right?
Her boyfriend said she had 1. He didn't
And
equate.
she said she had 2.
She said she had 2. So the evidence in the case is she had 1 or she had 2. And now the prosecutor is saying, well, she could have had more. And he's
Why is that a problem?
Well, it's a problem because it's not supported by the evidence. It's in order for the prosecutor to argue that, it's got to be a reasonable inference. Well, there's no facts that he's inferring that from if all of the evidence says that it's 1 drink or 2 drinks. And in fact, in his argument, he says, well, the boyfriend said a different thing, so that means it could have been more. But the boyfriend said it was less, not more. So he's arguing an inference that's not supported by the facts.
What if the defense presented evidence that if they both testified she had 0 drinks? Would the prosecution then be precluded from saying she had more than 0 drinks? Because
I
they
guess
know,
it would depend on the context. If he's arguing that here he's arguing she said she had at least 2 drinks, and that's not the facts.
So at the beginning, the very first thing the prosecutor says in closing argument is 2 Malibu rums and pineapple. That's what the defendant said. Later on in her argument, she says that, repeats that again. And then the third time she gets to it, she says at least 2. So are you saying that, I mean, you can't really say she's misrepresenting what the testimony was, because she actually was pretty clear what the testimony was earlier in the argument. So I think you're saying this is an inference that can't be drawn.
I think that's correct, Your Honor. The prosecutor is drawing an inference that's not supported by the facts.
But you have the observations of the driving, you have her performance during the walk and turn, you have the observation of both troopers at the scene, you have the odor of alcohol in the cruiser, you have the odor of alcohol in the booking room, as to the last 2 points that did not exist prior to the trooper having her either in the cruiser or in the booking room. So if you take all of that together, why is it not a fair inference that she could have had more than 2?
Well, the defendant's position there is that none of that evidence necessarily means or even necessarily permits an inference regarding how much she had to drink. The prosecutor here is arguing, he's talking specifically about how many drinks she had, not about is she drunk, is she intoxicated. And I would suggest, Your Honor, that the evidence that you're talking about goes to her level of intoxication, not how many drinks she's had. And it doesn't necessarily support a reasonable inference that she had more than 2 drinks when all of the evidence in the case is that she had 1 or 2. And I would also point out that there's other evidence in the case, even from the officers, that she pulled over appropriately, she was able to hand over her information appropriately. The first officer initially doesn't even talk about slurring of words. And so there's other evidence here that she wasn't so intoxicated that she must have had more than 2 drinks. So again, the defendant's position is that this isn't something that's a reasonable inference, and that it's prejudicial because it went to the heart of the case, because this is a case about was she intoxicated or not. And the prosecutor is using this evidence to say, well, she admitted to drinking and she might have had more than 2 drinks. So it goes right to the issue of whether or not she's intoxicated. If there aren't any other questions, then I'd be happy to rest on my brief.
Justice Massey, Justice Neyman?
More questions?
Seeing none, we will have you rest on your brief. And Attorney Herron, when you're ready.
Sure. May it please the court. My name is Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I'll start where we left off. The prosecutor's closing argument, which referenced facts and evidence and reasonable inferences therefrom, did not create substantial risk of a miscarriage of justice. As been pointed out, the defendant testified to both officers. The defendant told both officers, as testified by each trooper, that she had at least 2 drinks. That she had
Did
2.
she say at least, or did she say
I'm sorry.
2?
She said I had 2 rum and pineapple drinks. So I think it's proper for the prosecutor to say that she had at least 2 drinks. I think it's a more than reasonable inference from the evidence that she could have had more, based on what has been already discussed, that she was driving negligently, that her eyes were red, glassy, and bloodshot, that her speech was slurred, that she had a strong odor of alcohol emanating from her breath, that she swayed and was unsteady on her feet. So I think it's from this evidence the prosecutor could safely argue that she had more arguments, Your Honor. She says the point is not the inconsistency of the number. The point she was making, which she explicitly says to the jury, is that the defendant admitted to drinking alcohol prior to driving. And I think that could not have been lost on the jury. So I would suggest there was no error in the prosecutor's closing argument, and there clearly was no substantial risk of a miscarriage of justice. And I also think this argument points out, which will dovetail into the first argument, why it's important to state your reasons on the record for your objection, because the defendant did object to the prosecutor's closing argument, but on different reasons than raised on appeal, and stated those reasons clearly on the record. So therefore, we know that this one, substantial risk of a miscarriage of justice. or when it's inaudible, or you can't tell the exact stated reason for the objection, I would suggest, and this goes to the first argument, that it's implicit upon the defendant as the one bringing the appeal, the burden to create the record. I disagree with my brother. I think the Wood case and the Woody case make it clear that it's incumbent upon the defendant to the portions of the record that are inaudible to recreate it or reconstruct the record. If there's no questions on the second argument, I will go to the first one.
Seeing none, you may proceed.
Sorry.
Go ahead.
Go right ahead.
The trial judge here properly admitted into evidence the defendant's statement explaining the reason. Oh, I'm sorry, I'm breaking up a bit. I apologize. The trial judge properly admitted into evidence the defendant's statements explaining the reason she performed poorly in the field sobriety test, and this does not constitute refusal evidence. She took the test. What the jury heard is not based on what the police report is. What the jury heard is the testimony, and that was that she took a test, and then she, according to the trooper's testimony, did not pass the test, did poorly on it, and her explanation was because of her wet shoes is why she did poorly. She was off balance because of her wet shoes. And I asked this court to look at the Brown case because I think it's very similar, and that clearly is admissible, does not constitute refusal evidence.
Your brother
I
says.
think I'm frozen again. Oops, I'm sorry.
We were able to hear you though.
Your brother says that the police report indicated a different sequence of events, and thus the police officer's testimony was particularly misleading because it took things out of order. There's a temporal issue, if you will. Can you address that, please?
Well, I would suggest this court can't because we don't have the police report. It's not part of the record. I actually have not read the police report, so I do not know what it says. But since it's not part of the record, I don't think this court can consider it. And I think what's important is what the trooper testified to the jury, because that's what matters is the impact on the jury. And the jury did not hear anything about a second test.
So in the transcript though, that when the prosecutor is talking about this evidence, is it a she, the prosecutor? Says, so she did one, and the second one she indicates
it's a female prosecutor.
She's described she indicates she wouldn't do the second one, not because she didn't want to, but because of the shoes. So it sounds like it did. The evidence that came in trial was different from, sort of did change the facts a little. But so suppose it did. Is that a problem?
I don't think it is, Your Honor. I think the claim raised is that the jury heard refusal evidence. And I think here it's clear the jury did not hear any refusal evidence. And as the judge said, I think the defendant would want that into evidence because it explains how she did poorly on the, not because she was intoxicated, but because of her shoes is why she did poorly on the field sobriety test. If there's no further questions, the Commonwealth will rest on its brief.
Justice Massing? Justice Neyman? Seeing none, we will conclude this hearing. Thank you both for your excellent arguments. Matter is under advisement. We are now going to take the morning.
And we are live.
Thank you. Our next case is the Department of Children and Families and Another versus Father, docket 20P148. This case is impounded, so we will not be using anybody's names. And as I understand it, Attorney Spanos, you will argue first for the appellant father. So when you are ready.
Thank you. Good morning. My name is Attorney Diana Spanos, and I am counsel for the appellant father. My client wishes for me to set forth the following arguments on his behalf. The crux
Are all of your arguments being made subject to the guidance of Moffitt?
Yes, Your Honor.
Thank you.
The crux of his argument was he acknowledged, in fact, that he was incarcerated at the time and that he was limited in terms of what he could offer. However, he believes that his attorney did not effectively communicate with him, particularly as the circumstances of the case changed. And they did change significantly. I'm sorry. Initially, he was in court on January 31st for the adjudication of paternity on the two children. And then they were in the following day on the first day of the guardianship trial. And although the record doesn't get into it, he was haved in on both days. And as an incarcerated individual, being haved in is not always a comfortable situation. And in fact, for many people, it's very uncomfortable. And he was up very early. They're left in cells for very long periods of time. He was very uncomfortable. And he then had to come back for March 7th date, which was the day that he testified. But he also knew that he was going to be back in the following date. And that was when he expressed to his attorney that he was very uncomfortable and really didn't want to come back. That being said, just because he didn't come back, the attorney, he tells me, did not communicate with him regarding how the case proceeded. And his position at trial was that he was in support of the mother. He would have also supported the grandmother as a guardian. But when the mother then chose to do the open adoption agreement, he was completely unaware of that. Now, no one at any time expressed to him that the judge could draw a negative inference by his failure to be there and participate in the proceeding.
Where in the record, I'm sorry to interrupt, but where in the record can we find that?
That no one.
Yes, apart from his representation.
I think I understand your question. I believe you can really tell from the March 8th court date when the judge actually says from the bench, you know, I was thinking about this morning that I could draw a negative inference. And the client, you know, basically says, well, he told me all day long he didn't want to be there. So you do have to, you know, look into the record a little bit. Clearly the judge did not tell him. And so they did have this conversation, and the judge says on March 8th, could you please communicate with your client because of the legal implications involved? And, you know, again, on that date, which I also found interesting, was that on February 12th, he should have had his criminal case, which was subsequently continued. But he believed, for right or wrong, that he was going to be released based on time served, my client, I'm saying. And on March 7th, it was clear on the record that the attorney hadn't spoken with him. He didn't know why the client was still incarcerated on March 7th. So moving forward, his criminal case didn't get heard until March 21st. The judge takes a negative inference against him on that day. There's some discussion on the 20th as to why mom is not there. But the judge drew the negative inference on the 21st. And then on the 22nd of March was when the mother did appear, and apparently there had been a pre-negotiated open adoption agreement. My client's position is that he would have liked to have known that. He did not know that. Part of the open adoption agreement was allowed the mother 2 months to put forth her own person as a potential adoptive placement. My client would have liked the opportunity to present his mother as that option. He did not get it. He didn't know about it until after the matter was filed on appeal. So again, he was limited, and he's not arguing, and I think he did participate at the trial to the extent he testified and acknowledged, I'm not in a position to take care of the kids. So that was the main crux of his argument. The second piece of it was that he believed that the judge appeared to know the mother's family quite well, and maybe was wearing the hat of the prosecutor as opposed to when he requested that probation go out that day. And certainly the law is that the burden is on the department to prove the case. And while it's understandable that the judge wanted the best record that he could have, it's not really the judge's role to take on that job. So,
but it isn't, I mean, a judge is not only authorized to consider the fitness of a proposed guardian's home, I think a judge is obligated to do so. Isn't that correct?
I would agree. I would agree with that. I mean, I do think that the burden, though, of providing proof, and it's kind of like the judge brought the evidence in, and then handed it to the department and said, okay, now enter it. It didn't go in as a court exhibit. But
Was there any objection at trial to the judge asking for this information?
no, the father's counsel did not object.
So is our standard of review substantial risk, or is it just waived?
Is it just what? I'm sorry.
Waived.
I think it's a substantial risk of miscarriage of justice. There's an overall level of, my client was overall concerned about the overall fairness of the proceeding. Again, I know that the other side argued that this happened during the guardianship portion of the trial, which is true, but that wouldn't have prevented him from offering up an alternative placement during the best interest portion of the trial either.
But the guardianship was not appealed nor consolidated below, right?
That's correct, Judge. So beyond that, if you have no other questions, I would rest on Father's brief.
Justice Massing, Justice Neyman?
No more questions.
Okay, seeing none, thank you very much, Attorney Spanos. And first, we're going to hear from Attorney Murphy
Yes, please.
when you're ready.
Good morning. Lynn Murphy from the Department of Children and Families. This case basically involves two questions. What constitutes ineffective assistance of counsel, and what actions are appropriate for a trial judge to take in determining the appropriateness of a guardianship petition or a proposed guardian? As an initial matter, the problem is father has not preserved either of these issues. In the ineffective assistance of counsel claim, he has not filed a motion for new trial. Therefore, we have no record from which you can review these claims. There's nothing, that is the purpose of the motion, to give the court, excuse me, an affidavit would have been filed and there would have been a hearing on that issue. This didn't happen. And similarly, father did not object, or any other party, to the actions taken by the trial court during the guardianship petition. There was basically criminal record, ongoing criminal behavior, and excuse me, I have allergies. Not only criminal records of grandmother and grandmother's partner, but grandmother was continuing to engage in criminal behaviors up to the time of the hearing. And this clarification of these matters was absolutely appropriate for the trial court to engage in. Father has not shown on the merits that his counsel was ineffective. Counsel took a number of actions, as I noted in my brief, and perhaps most compelling, the evidence was overwhelming of father's unfitness. He had a lengthy history of violence, and while counsel claims that the situation had changed at the time of trial, that was not the case. Father was incarcerated for most of the time that the CMP was pending, and he remained incarcerated at the time of the trial. And then furthermore, he was given 2 additional years to his sentence. So there was really nothing that his counsel could have done other than what he did, which was represent him to his best of his ability through cross-examination, challenging the department's evidence. And I really have nothing else to say on the matter. I will rest on my brief and ask you to affirm the trial court's decision in this matter, unless you have any other questions.
I have one brief question on the second issue. The judge asking DCF to gather information, if you will. I know your first argument is there's no standing. Assuming there is standing, what is our standard of review on that issue? Is it just waived, or is there a standard of review?
Well, I think right, even if father had standing, no party objected to the gathering of this evidence, and it wasn't the department, it was the probation officer.
Correct.
That was asked. And again, no party objected because of the relevance and appropriateness. And at this point, the guardianship petition the evidence has to show by a preponderance of the evidence that the guardian is qualified, and also that the best interests of the children are served. And that is the standard of review for the guardianship.
Does waiver apply or not?
It was not met by the grandmother, the maternal. Oh, I'm sorry.
So my
Could you
brief
repeat that? I'm sorry, I missed
follow-up
it.
question is, does waiver apply or not?
Yes.
Is the issue
Yes.
waived?
Both issues are essentially waived, yes.
There's no case that has brought the substantial risk of miscarriage of justice standard into parent protection proceedings, is there?
Not that I know of, and it certainly wouldn't apply in this situation. If there are no other questions. Oh,
No other questions for Attorney Murphy? Seeing none?
One more.
Sorry, Mr.
It's, it's the probation office is, attached to both the juvenile court and the probate and family court, to facilitate the functions of the court. Is it prosecutorial? I mean, are there limits on what a judge can ask probation to do in these cases?
yes, there will certainly, I mean, the judge is the controlling mind, and he or she has a duty beyond just sitting and listening. And he, as a finder of fact, there are actions that a judge must take. And in this case, the judge was, again, in these parent protection cases and in the guardianship cases, we're trying to determine, the judge is trying to determine the best interests of the child. And criminal behavior, criminal involvement, and the mother's suitability of the mother's grandmother's residence were absolutely relevant to that guardianship petition. And it wasn't as if the judge just was, there was evidence presented to him that showed there was conflicting evidence on those two key points. His grandmother's testimony was not found credible. So at that point, the judge really did have a duty to look into, try to resolve some of these factual issues. And that is exactly what happens here. If there were no other questions, I'll rest on my brief.
Thank you, Attorney Murphy. Attorney Freitas, if you give us a second when you are ready.
Thank you. Good morning, Your Honors, and may it please the court. I am Christina Freitas, and I represent the two minor children. With respect to Justice Massing's question to my sister just previously regarding whether there are limits on what a juvenile court judge can do in these cases, yes, there are, but the judge did not exceed those limits in this case because he's directed by General Laws, Chapter 119, Section 26, B2I, to have the probation officer or another qualified agency conduct a home study of the proposed guardian. And he was required to do that. He could not dispense with those statutory requirements if he so chose. And that is precisely what he did. He directed a probation officer to both collect publicly available information in the form of a police report, and also to conduct a personal home visit to the home to inspect where he was considering sending the children. And it's of significant importance because termination of parental rights or any disposition of a child is one of the most important decisions a juvenile court judge can make. And as a result, he should have as much information in front of him in order to make those decisions. He did not direct the department to enter that evidence. The department did so without objection by any counsel, including father. And as a result, I believe that issue is waived. I would like to address two additional points. First, the purported error that father raised, both of them, they do not address any of the central questions before this court, the children's best interest and father's unfitness. The ineffective assistance of counsel claim is not only procedurally weak because it was raised for the first time on appeal without the benefit of an evidentiary record, but also it's substantively weak because the ineffective assistance of counsel claim complained of that father wasn't advised of the potential for negative inference, or didn't seek a continuance after a change in position of the mother, they don't reach the children's best interests or diminish the overwhelming evidence of father's unfitness. The negative inference but was one of the 58 uncontested findings of fact and 44 conclusions of law. And even the trial judge noted that it was only one factor in the analysis. In contrast, the judge made over 30 uncontested findings regarding father's history of incarceration, the physical abuse mother suffered at father's hands in the presence of the children, and his failure to participate in any services to remedy those issues. The guardianship error claim is similarly procedurally flawed because it lacks an indispensable party, since the proposed guardian didn't appeal. But that claim too is substantively flawed because the judge did not abuse his discretion or make a clear error of law in finding that adoption and not guardianship was in the children's best interest. These children were already in the permanent custody of the department since the first permanency trial in October of 2017. From the perspective of the children, this court should affirm the termination decrees. Father doesn't contest a single finding of fact in the 58 findings of fact and 44 conclusions of law. The lower court made no error when it found that father was unfit and would remain so into the indefinite future, based on his severe and repeated perpetration of domestic violence on the children's mother and in the presence of the children, including one time with a machete. His unrepentant criminal conduct that left him incarcerated, not only at the time of trial, but where he had been for the previous 15 months and the majority of these two minor children's lives. His failure to engage in a single meaningful service, despite the availability of those services, even while incarcerated, and his failure to ever have been a primary caretaker for these children. And Your Honors, if there are no other questions, the children request that this court affirm the judgment and allow the children to be freed for adoption and let them have permanency.
Does the panel have any additional questions? Seeing none, we will conclude this hearing. Counsel, these are always very difficult cases, and we appreciate all of your arguments on behalf of your respective clients. Thank you all.
And we are live.
Excellent, thank you. Ms. Leslie, you may begin.
So my first argument is that Bodkin is not an expert witness or a witness. First, I will begin with what Bodkin's lawyer stated in their brief as it pertains to this document here, where in this document, the defendants, the remaining three defendants here, had stated that the examination does not pose a serious risk or harm, pain, or undue embarrassment to the plaintiff. They promised that in this document they filed with the court dated
Could you tell us what you're referring to, where it is in the appendix?
The actual motion that Bodkin lawyer had mentioned in their brief that was opposed by us.
Okay, Ms. Leslie, is that in the record somewhere?
No, Bodkin lawyer mentioned it in his brief.
Okay, so the record does not have that document?
Oh, no, but what Bodkin lawyer did, he mentioned this in his brief, saying that there was two motions filed and it was this was one of the two. And they said we never opposed it, and it was opposed. And in this document on this page, they acknowledge that the examination does not pose a serious risk, pain, or undue embarrassment to the plaintiff. That's document number one, showing that they made this promise to me. Exhibit number two, which I have here again, Bodkin lawyer wrote in his motion that we never opposed the document, and it clearly shows that the plaintiff, that when they filed the document, it shows that we opposed it. Again,
what paperwork is that you're referencing?
Okay, so this is the document that Bodkin's, that the defendants filed on November 19, 2014. Bodkin lawyer mentioned again these documents, and what it is, he stated that we never filed an opposition at all times. We have always opposed this evaluation. Now, get into the other question is, the defendants made promises to me that they would pay for the evaluation, as it's highlighted, that they would pay for me to attend this evaluation at Dr. Bodkin's room. It says, we agree to provide sufficient funds to Miss Leslie in advance to the examination to cover the cost of her transportation via taxi between her home and McLean Hospital. They then turned around with a motion to compel to say they're not going to pay. And basically, okay, this other document they also mentioned here. They said that Dr. Bodkin will have a private room for the examination. Again, these are coming from the three remaining defendants making all these promises to me. And then they turn around and with this on-file document, which they mentioned all throughout the hearing, and refuse now, it's a motion to compel me to go to their law office to do the evaluation. And here they're stating that they will not use an IME vendor. They want to use Bodkin. In addition, they refer to Bodkin allowing me, however he is certainly agreeable to having the examination tape recorded by your client. This did not say anything about Bodkin tape recording me because I requested the recording. And then this was the actual motion to compel, to threaten me to go. So I went under the guise of the threats to, if I didn't go, I felt that the court would have dismissed my case. Now here is the actual affidavit from Bodkin that was received by my attorney on December 31st. Here Bodkin wrote on paragraph 4, in addition to saying that the defendants retained him, he wrote in paragraph 4 that the defendants have asked that I perform a psychiatric evaluation of Pauline Leslie to offer my medical opinions concerning the psychiatric impact of a car accident which occurred on December 22nd, 2010. Bodkin never asked me any questions about this car accident at the evaluation. Therefore, he lied to me based on this affidavit that he signed on December 31st, 2014. Next, Bodkin wrote a report, which this should be redacted from the record, it's impounded. In this report, Bodkin stated on page 4, which is with the court's record, which would be technically page 7 on their exhibit. Bodkin stated he intentionally, on the first paragraph, intentionally inquired about it only a little. He's referring to the accident, how it impacted me. He definitely wrote in his report that he intentionally inquired about it a little bit. Now, to go to page 3, which would be technically page 5 in his exhibit, Bodkin mentioned somewhere that his last notes available to him was March 4, 2014. Bodkin also said he had access to my medical records as of May 22nd, 2013. I never filed a lawsuit at that time. How did Bodkin get access to my medical records prior to me filing a lawsuit on August 2013 of that year? So therefore, the defendants, when they requested that motion to reconsider, they stated in order to get that motion to reconsider that Bodkin was basically just hired and they just got medical records. And this we're talking about in November 2014 in their motion to reconsider, that he was basically just hired on this case and that they just got the medical records, which is not true, because if Bodkin was just hired, why didn't Bodkin provide the records that was on those CDs that dated August of 2014, when he clearly said the last records available was also March 4, 2014. On those CDs, when the defendants requested the motion to reconsider, they argued that they needed CDs that they just got in August. On the August CD is my therapy notes from August 2014. So they lied when they told the court that they had just basically retained this doctor who had already stated that he had my medical records available before I filed a lawsuit. Now, Bodkin's lawyer also mentioned that we didn't oppose Bodkin. This was a motion that was filed. It was dated March. It was mailed to the court on March 27, 2015. This was to oppose Bodkin because he was untimely. Next, these are motions where we complained to the defendants prior to them continuously retaining him for his service. This shows that we complained about Bodkin's conduct. This is prior to them even asking him to do the video deposition. There was a bunch of exhibits attached to this motion provided to the defendants about his wrongful conduct, and they continued to retain him. Next, when I complained to the defendants, they wrote in this letter, this is from Joseph Aronson, stating that it was travelers who retained Bodkin.
What's the date of that letter, please?
It is November 10, 2017.
Thank you.
If you look at Bodkin's original affidavit, he says Kinston and Barrett retained him. On top of it, then I wrote to Travelers. Travelers now said neither Morrissey nor Travelers had any involvement or retained this doctor. Again, these defendants are not telling the truth, and they're being dishonest and sending me around the block, and now are trying to imply that Judge Brian Davis appointed Dr. Bodkin. So now none of these defendants retained him. Therefore, how can then Bodkin claim that he's a witness when nobody's claiming to have retained this man? After they benefited from him, they ratified his behavior. If they believe that Bodkin was a problem, if you buy a microwave and it's broken, you do not pay for a broken microwave. You return that microwave or replace it. The defendants continue to retain this doctor, and evidence show that he's been involved in my case prior to me filing a lawsuit. And now the defendants are all claiming they didn't retain him, and now are trying to imply that there's judicial misconduct, that a judge appointed this man. And that's what Bodkin's lawyer leaned on in court. In addition, Bodkin's lawyer stated that his name doesn't even appear on the pleadings during the hearing, as if he's implying that he doesn't want to get involved in this, whatever is going on in this case. Now, I have here a little argument that I'm making as well, is that a witness is a person who observed, saw or heard something. That's the definition of a witness from the legal dictionary. And an expert witness is one who has the skills and training to determine a fact and issue. So Bodkin allegedly was hired to determine a fact and issue. Bodkin never determined a fact and issue. What Bodkin did was call me a gal, rolled his fist at me, and asked me if I was a jealous woman when it comes to men, and asked me if my grandparents are married and if they were both Black, and what do your mama do for work? And he was highly inappropriate, to the point that I was chuckling there. I cried to him, told him I was in pain, and he disregarded everything. And then when I explained, he kept bothering me. After the third hour, I was drowsing off. I told him, listen, I'm tired. And he goes, well, count the pills. He was just talking things that didn't make any sense to me. And when I said to him, you know what, I'll just email it to you. He goes, well, they'll flip at me. Just CC me, email it to me, and CC the defendants. He then had the defendant's secretary enter the room with a laptop device. No one told me what that device was. In fact, they put it outside of my vision by placing it on a chair next to Bodkin. After Bodkin's inappropriate conduct the whole time, and I can see and hear the noise going on outside, people standing there, it's glass front, no privacy. Bodkin got up around at the fourth hour and left the laptop device on the chair and walked out, and basically, in so many words, asked the secretary, can you call my ride now? So I'm like, okay, what is really going on? And the fact that these defendants are now claiming they didn't retain him, Bodkin should never enjoy the absolute privilege if somebody didn't retain him. No one retained him. And so my argument is he committed a fraud, because he claimed he was evaluating me on the impact of a car accident. And this man never inquired, Miss Leslie, what happened on December 22nd, 2010? How do you feel? I've been to countless IMEs, as everyone knows. I have been to about 6 IMEs. I was there no longer than an hour each. They provide transportation if it's not in the local area, and then, when I got there, when I actually had to take a bus, I took my daughter's lunch money, because the defendants promised to pay for the to pay for me to get there. I had to take my daughter's lunch money. I wasn't working because of the accident. Took her lunch money of $10, parked my car in a bank parking lot. And it could have been told, the bank manager said he was going to tow me if I didn't remove the car in Lynn. And I had no choice but to jump on the bus, go all the way to Boston, beg a friend to pick me up from Haymarket to drop me off at that location. And then as soon as I arrived, Bodkin basically asked me, how was your drive into Boston? I said, I didn't drive into Boston, and told him my whole ordeal. And so my ending argument is this, and I have it written. Bodkin is a microwave. The defendants are the purchaser. The defendant went into a store, purchased a specific microwave, brought it home, plugged it in, and it didn't work. The average person would return the broken microwave to the store and get a refund or replace it. They did not they would not pay for the broken microwave. Here, the defendants did not return the broken microwave. They kept it for those services, the conduct. They continued to pay him for his false report and then his false testimony in December 2015, where he even implied to put a pill in my Cheerios without my consent. In addition, the defendant was satisfied with the way the doctor conducted himself, satisfied with the report, and satisfied with his testimony. Therefore, they cuddled this behavior, which is ratifying the behavior, as it's stated in the McCormick case that I have listed, where you ratify an individual's behavior. You don't pay somebody for a bad product. If you know the doctor did not conduct himself in the manner that you hired him to do, as he stated in the report, he only inquired about my accident a little bit. While he was asking me about my bum, he was asking me about he wanted to know about my private part. He's calling me gal, he's rolling fists at me. And I was terrified to be in that room, absolutely terrified, that I cried to him. And he basically shut me down and said, dry your tears, I have a lot of grounds to cover. He disregarded, and I believe when all the activity was going on in the glass conference room, I saw Mr. Ronson standing at the doorway. And I was not without my counsel. I was without counsel. And there's no way would anyone classify a doctor's behavior in an office. And they're going to state, oh, well, you know, Bodkin we are an MBE. You're not an IME vendor. You're not an IME vendor. The cases they cited all rule in my favor because these people are IME vendors. They do this for a living. They go out, they get these people, they randomly select them. The defendants picked this man, chose him, and then tried to blame the court for appointing him. The court did not appoint Bodkin. And so my argument in the end is the defendant later on ratified the behavior. Even if they believe that Bodkin did not do what they said, they ratified his behavior, paid him for his behavior, paid him for the report, and paid him for the deposition, in which he completely falsified information against me. And I offered the recording for the record. And for that reason, the court should not consider Bodkin an independent contractor or even qualify for the absolute privilege because they have all denied retaining him. Thank you.
Thank you very much, Ms. Leslie. Ms. O, you have 10 minutes. When you start, the clock will start.
Thank you, Your Honor. May it please the court, Heidi O on behalf of the defendant appellee, Dr. Bodkin. Respectfully to Ms. Leslie, I think there is no dispute here that Dr. Bodkin's only role in this case was as an expert.
I'm going to ask you to pause for a minute. Ms. Leslie, we can't see you. You still with us? Oh, okay, great. Please continue, Ms. O. I'm sorry. That's okay, I'm sorry.
All right. Dr. Bodkin's only role here was as an expert witness retained to perform a court-ordered Rule 35 exam. And we say that because that was his only role, the absolute privilege applies to his examination, his report, and his testimony.
Does it matter who retained him?
Honestly, I don't think it does with respect to Dr. Bodkin. Obviously, Attorney Suslek will speak to that in his portion of the argument. But with regard to the absolute privilege, I don't think it does. It's not relevant, Your Honor. He clearly was a witness in this case. He clearly gave testimony in this case. And so to move on, the two sort of main points Ms. Leslie is trying to make is, number one, that these various statements made by Dr. Bodkin were not pertinent, if you will. That he asked her about her private parts, that he asked what her mama did for work, things of that nature, and she's characterizing those as not pertinent to the issues in question. And I'd refer the court to Sullivan versus Birmingham, which talks about that standard of what is pertinent. And it is a wide standard. It is not the standard of admissibility. Is it relevant? Is it material? It's really just does it have some relation at all to any of the issues in the judicial proceeding? And in this case—
So what Ms. Leslie's mother did for a living have to do with the claims stemming from the car accident or the tractor trailer accident?
Sure, Your Honor. what you have to understand, and this is both in Dr. Bodkin's report and his testimony that is included in the record, is that Ms. Leslie was alleging very significant damages. Years of complete disability as a result of this car accident. And what's also in the record and obvious is that Ms. Leslie had a very serious, if you will, traumatic childhood and young adulthood. So as part of that examination, Dr. Bodkin's examination, it's necessary to understand, to really delve into what is her background, what did her mother do, because her father left the house at a certain point, her mother then left. So those kinds of things are important to understanding not only Ms. Leslie's general background, but her sort of, if you will, psychological baseline, and determining whether the issues she claims now are causally related to the car accident. So
I'm just curious, how far does it go? I mean, the issue, the absolute privilege you say applies to questions that are pertinent, to conduct that's pertinent. I mean, it would not reach, say, assaultive conduct, right?
Of course not, Your Honor. And sorry, I didn't mean to cut you off.
That's good. So what, and does some of the allegations border on assaultive? The clenching of the fists and the the like locking her in the room without water type of thing?
Sure. And I can certainly speak to that. With regard to assault, I think you can envision a situation in which someone would clench their hand, clench their fingers into a fist and not have it not be assault. So for example, if Dr. Bodkin had asked her, did you brace yourself before impact? Or do you feel a knot in your stomach when you're in a car now? Because she's alleging PTSD and an inability to drive. There has to be more an understanding that this is a motion to dismiss pursuant to 12b-6. There has to be more in Ms. Leslie's complaint than just the mere allegation that he clenched his fingers into a fist. There has to be some element of intent by Dr. Bodkin to create that that fear, that apprehension of imminent physical harm. There also has to be some allegation that it was reasonable. It's not enough that Ms. Leslie subjectively felt threatened. There has to be some reasonableness attached to that feeling of threat or.
Can I ask you one more? Can you clarify for us the timeline of when Dr. Bodkin was retained and vis-a-vis the documents he had?
Sure. If you look at Dr. Bodkin's report, the date, which is our impounded appendix, the date referenced by Ms. Leslie in May 2014 actually refers to the records that he received, not the date that he reviewed them. So it's, and I can, turn to that specific page. It is, I was provided with the medical and mental health records of Ms. Leslie that were available as of 5/22/13. 5/22/13. So that refers to the records that he received, not the date that he was retained or the date that he reviewed them.
He uses the passive tense there, but presumably those were provided by counsel for the defendants, who will ask the other defendants who that was, which they received via discovery.
Presumably, Your Honor, I don't actually know. I should say I don't actually know how he received them.
Right.
I think the other issue that needs to be addressed here is the question about the recording by Dr. Bodkin. The wiretapping statute cited by Ms. Leslie requires the recording to be secret. And the court can look to the circumstances surrounding the recording to determine whether that recording was actually secret or not. And if you look at the case of Glick, that's G-L-I-K versus Cunniff, C-U-N-N-I-F-F-E, 655 F3D 78. That's a First Circuit Court of Appeals case. That case involved a cell phone that was used to record. And the court found in that case that you didn't have to know that the cell phone was actually being used to record. As long as the phone itself was visible and that it is a device commonly known to be able to record things, that's sufficient. And in this case, not only was Ms. Leslie recording herself, so she knew that she was being recorded, but the laptop, which allegedly was recording the session, was in plain view. It wasn't, secreted away under the desk or something like that. So I think with regard to the allegation that this recording was done in secret or illegal in some way, that does not hold water as well. I guess in the last 30 seconds that I have, let me just say, with regard to the improper publication of or somehow invasion of Ms. Leslie's privacy because it was in a glass front conference room, there is nothing in the record before the court and certainly nothing in Ms. Leslie's complaint that suggests that anyone other than people who work at the law firm heard or saw anything. So her privacy was adequately protected in that regard.
And time has expired. Mr. Suslak, you have 5 minutes. The timer will start when you start.
Okay, thank you. So with the limited time we have, I just want to hit on a few points. The first, and really the central issue here in terms of my clients, Travelers, Kingstown, and Mr. Barrett, is that Ms. Leslie's claims against these three defendants essentially are a vicarious liability claim. It's the allegation that Travelers, Mr. Barrett, and Kingstown are vicariously liable for Dr. Bodkin's alleged misconduct at the IME and his alleged false testimony at the deposition that was played at the trial in the Suffolk County case. The cases we cite in our brief are directly on point here. Dr. Bodkin was an independent contractor. The only role between Dr. Bodkin and my three clients was the fact that Travelers paid Dr. Bodkin for his services.
Who
in this
selected
case.
him?
It's my understanding that he was selected by defense counsel in the underlying case. That
Defense counsel for who?
for
Barrett and
Mr.
Kingstown?
Barrett in Kingstown, correct. And the cases that we cite in our brief, the Paradoa case and the Goodman case, really are dispositive of this issue as it pertains to my clients. Those cases both concerned an IME doctor who allegedly engaged in some misconduct during an examination, and the court in both those cases held that the mere retention of the IME doctor was insufficient to impute liability to the insurance company. You need to show some evidence of control, supervision, or direction on the part of either the insurer or here, Mr. Barrett in Kingstown. And there's just
And
not
on
here.
appeal, you're representing all three, right?
That's correct, yes.
Do you help clarify or address Ms. Leslie's, the evidence that somebody was disavowing having retained Dr. Bodkin?
I can, if yes, there's letters that are in the file that were sent to my office, to Morrison Mahoney, and then to defense counsel attorney Aronson. They were sent to our respective offices. It was Mr. Aronson's former firm that's now closed, and Morrison Mahoney saying that either the McCormick Group or Morrison Mahoney retained Dr. Bodkin. They were 93A letters essentially sent to both of our firms. We both sent denials saying that our respective firms had not retained Dr. Bodkin. Our role in the underlying Suffolk case was representing travelers. The claims against travelers were severed and stayed. We had no involvement in the defense of the underlying claim beyond monitoring the events of the case and reporting back to travelers. We attended hearings, there's no disputing that. We attended depositions. And once we were severed and stayed, we participated in no discovery, and then summary judgment was eventually granted in that case. So that, I think that's the letters that Ms. Leslie's referring to, and those are part of the record. And I can give you at least the letter to Morrison Mahoney is dated, it's in volume 3 of the appendix A022. So it's our position that in terms of the vicarious liability point, there was no direction, supervision, or control of Dr. Bodkin by any of my clients. You have affidavits from the traveler's claims handler and from Mr. Moon, who is the president of Kingstown Corporation, and Mr. Barrett, who is the driver of the truck. Neither Mr. Moon or Mr. Barrett have ever met or spoken to Dr. Bodkin. Travelers paid Dr. Bodkin's bills. We don't dispute that. It's a common arrangement. When an insurance company is defending its insured, an expert is retained, the insurance company pays the bills pursuant to its policy. That's what happened here. Beyond that, travelers had no say whatsoever in what Dr. Bodkin did or what Ms. Leslie is alleging he did in that IME or in his testimony at trial. We weren't at the deposition of Dr. Bodkin. Travelers asked no questions of him, and it had no further role beyond paying him for his services. And just very briefly, the last 2 points, Ms. Leslie.
I'm sorry to interrupt. Did the Paradoa case involve the retention of an IME?
It did.
And was the defendant insurance company the entity that retained the IME?
The defendant insurance company in that case retained an IME company that sourced the exam out to one of its doctors that were on its roster. But the suit was against the insurance company for vicarious liability. And it's a very similar fact pattern to this case, actually. If you look at it, the doctor allegedly verbally abused the plaintiff during the exam. The facts are very similar to this case. And I know I have very little time left, but just briefly, in terms of the default argument that's raised by Ms. Leslie in her brief, it's our position that she's waived that case, that argument. It wasn't raised in summary judgment. The Horner case that we cite in our brief, when an argument's not raised in the lower court, it can't be raised for the first time on appeal. So we view that as a minor clerical error. We initially moved to dismiss this case. That was denied, and there was a short lapse beyond the 10-day period where we didn't file our answers, but the answers were docketed by the court. The court never acted on Ms. Leslie's motion. In our position, that issue was waived, and regardless, it was a clerical issue. And then on the lack of discovery, Ms. Leslie never filed a Rule 56F affidavit, which we think bars her from bringing up that argument now.
And you are out of time. Thank you very much. It's a very interesting case. The matter is deemed submitted. We will take it under advisement. Has joined us through the office of the trial court. She will simultaneously be translating for Ms. Burgess through the telephone while others are presenting. And when it is her turn, both Ms. Burgess and Ms. Crispin will become live so that we will be able to hear them. Prior to starting the hearing, we had a conversation with all parties and the interpreter about the best way to proceed. And this is what we agreed upon. And no one has objected to the manner in which we are going to proceed. Ms. Crispin, if I could ask you to unmute yourself for a second, and I will swear you in.
Yes, Your Honor.
If you raise your right hand, do you faithfully and solemnly swear that you will translate these proceedings to the best of your knowledge and ability from English to Spanish and Spanish to English?
I do. Carla Crispin for the record, Your Honor.
Thank you very much.
Thank you.
Okay, if there are no other preliminary matters, Ms. CERDA, you may begin, and you have 13 minutes. The clock will appear when you begin.
Good morning. May it please the court, Elizabeth CERDA, defendant. So I've raised a number of issues in my brief, or in our brief rather, regarding the granting of summary judgment in this action.
Just make sure you slow down so Ms. Crispin can get everything, okay?
Sorry, competing interests between the time and the translator. So for one, we raised issues of facts, material facts in dispute in our oppositions to summary judgment. For one, the amounts that the defendants, or rather the plaintiffs, were soliciting did not match up with the evidence that we provided to the court bank records, unit ledgers. The amounts that they sought for both priority and non-priority amounts were inaccurate.
Slow down.
Sorry. If you can just signal, maybe the interpreter can just raise her hand if I'm going too fast, that would be helpful.
Perfect.
We also raised issues as to whether these, the penalty fines that were levied to our units were properly assessed and whether the condominium fees that were levied between 2016 and 2017 were properly and duly assessed pursuant to the governing documents of the condominium.
Was that case the subject of a different appeal?
So there's the prior action that has to do with the prior board's breach of fiduciary duties, the 2016 action. This action is a collections action filed by the trustees concerning condominium fees, penalty fines, and special assessments. So to that extent, they're different.
And even if you're right that they shouldn't have assessed what they assessed, or there's some issue with the amounts, doesn't the statute require you to pay it in any event, and then you may have recourse? But here you withheld it, right?
So yes and no. Pursuant to case law, typically the statute with condominiums is you pay and then pay under protest and seek judicial relief. However, we filed a motion for preliminary injunctive relief pursuant to Blood versus Edgars, seeking relief from the court in that they paused the collections actions from going further until we sought judicial determination as to the legality of the assessments. So we raised issues as to whether the condominium fees were properly levied because the board did not provide us with a budget as they were supposed to, per the governing documents of the condominium and per the condominium statute itself. We also raised the issue of whether the penalty fines were appropriate. There are material facts in dispute regarding to that. The board alleges that we had surveillance cameras in common areas, and that's patently false. We had security cameras in front, in my unit and in Carmen's unit, not in the common areas. And so we moved for preliminary injunctive relief, showing that there was a risk of irreparable harm, meaning the plaintiffs were going to overtake our units, showing that there was no imminent risk to the trust because we never stopped paying our condo fees. There was never any risk to the operations of the trust. The items that we didn't pay were the penalty fines and also a special assessment that the plaintiffs themselves did not pay. So I provided the court with evidence of the fact that this is a 6-unit condominium. I own one unit, Carmen owns another unit, and one of the trustees is the trustee of record for the 4 other units, and his units did not pay that $140,000 special assessment either. So there's another material fact that would have precluded summary judgment. If no one
can I interrupt you?
Sure.
So you sought preliminary injunctive relief or a preliminary determination, and the judge ultimately denied that motion, correct?
The motion for injunctive relief, yes.
So under the Blood case, which I hope you're familiar with,
yes,
doesn't that require at that time, if you have not obtained a prior judicial determination of illegality, that you must pay first and then resort to other remedies?
I would say so, yes. But unfortunately, the amounts they were seeking were exorbitant. They levied a $140,000 special assessment on 2 weeks' notice, expecting us each to pay $20,000. And then it turns out that 18 months later, they had not paid that themselves.
No, and that strikes me, assuming the facts of that are true, as being unfair. The question is whether or not our case law or the statute itself carve out such an exception. And is there any case law or authority that you can point us to that says, yes, when you can't pay, you have another remedy?
I don't know if there's case law that says when you can't pay, but I cited Baker versus Monga and the Prosser case, wherein they both contemplate the possibility of extraordinary circumstances where you may potentially exempt that pay and then protest. It's in my brief.
Yep, pages 48 and 49.
Yeah.
Got it.
So, and in this particular instance where we provided the court with evidence that these, the defendant's units had not paid this exorbitant assessment themselves, that they filed a collections actions against our unit, but did not file any against their own units, that the penalty fines were potentially illegitimate because of the case law that I cited. So Noble versus Murphy, Johnson versus Keith, they can't control conduct within a unit. So that to me would have been grounds.
Let me interrupt you. I'm sorry. My follow-up question, though, is as I understand, at least the Baker case, it contemplates that when there is the possibility of, or when there are extraordinary circumstances, under that circumstance, it might warrant injunctive or equitable relief. Here, the judge didn't make that determination. So is there any other authority that I'm missing for this?
I don't believe so. I think we've challenged the denial of the injunctive relief as part of this appeal.
Okay, thank you.
Those cases, they mention the possibility of this exception, but no case has ever applied an extraordinary circumstances exception, right?
Not to my knowledge, from what I could find. But that's in reference to summary judgment and the contention that we had to pay those amounts. But in reference to the denial of the motion for injunctive relief, I think there were grounds demonstrating irreparable harm and risk to us. We had grounds demonstrating the balance of interest favored us. The trust would not suffer any irreparable harm if the court paused this collections action pending judicial determination in the 2018 action I filed. So as I mentioned in my documents, Ms. Burgess and I filed an action in 2018 seeking judicial determination and declaratory judgment on the legality of all of these charges, on the legality of the condominium fees, which we did pay under protest, on the legality of these special assessments that appeared to be fraudulent and targeted to oust us from the condominium, on the legality of the penalty fines that were levied against us, in complete violation of condominium case law, and which also demonstrate arbitrary and capricious enforcement of the rules. So the trustees as tenants violated all sorts of rules and continue to violate all sorts of rules at the condominium. We provided evidence of that. It's in my affidavit in our oppositions to summary judgment, and they're never sanctioned, but yet the trustees had no problem levying improper fines, daily fines against our units for cameras maintained within my unit and within Carmen's unit. So
brief, Ms. Serda, you ask for costs and expenses. What do you say you're entitled to and why?
Well, we have had to, so after they filed these actions, they went to our mortgage bank and demanded funds for alleged priority amounts and legal fees on behalf of our units. Our bank paid approximately $8,000, $4,000 for Carmen and $4,000 for my unit in majority legal fees. And the plaintiffs alleged that we owed somewhere in the ballpark of $500 in condominium fees, which was not true. In fact, what they did was they used the current month of condominium fees and presented that to our bank. And then the bank dispersed.
But none of that is before us on the appeal, right?
I don't think so. I think that's part of the declaratory judgment that we're seeking in the new case, where we're asking the court to determine that was improper.
Are you still in the unit?
Yes.
And there's a subsequent litigation? There's a new case?
There's the case that's seeking declaratory relief, invalidating all of these charges. And
on these very same assessments that are at issue here.
Yes, yes. So we're seeking declaratory judgment therein that looks at all of the facts pertaining to the cameras, pertaining to the trustees' arbitrary enforcement of collections, and that invalidates these charges. And that looks at the tortious interference with our mortgage contract, because the bank dispersed these amounts, did not notify us in contravention of the mortgage contract clauses. There's abusive process if that special assessment that they sought was illegitimate and their own units didn't pay it. What was the objective of this action? What is the objective of this action? Is it really to collect these funds, or is it to oust us from this condominium and overtake our units?
I apologize because I'm not sure if this is in the record or not, but have all of the assessments and fees been paid? Have some of them been paid, or have none been paid as of today?
Some of the assessments have been paid. We obviously did not pay the $140,000 our share of that special assessment, and another one that they levied for $25,000. But we've paid, these trustees have levied 5 assessments since they took over. We've paid 3 of those.
Thank you.
Including a recent assessment issued this year.
And not the penalties either.
Not the penalty fines, no. They've levied, I think, somewhere over $60,000 in penalty fines from the last time I've seen a unit ledger. And that's part of the problem is assessments aren't properly levied if you don't provide unit owners with invoices. So the last invoice I received, and I mentioned this in my brief, the last invoice I received for penalty fines was in January 2018. However, when opposing counsel filed amended affidavits in 2019 in this action, they alleged increased amounts for which invoices were never served upon us for penalty fines. And they also went back and increased prior amounts without serving invoices for those increases. And again, these are things I delineated in my opposition to the motion to file amended affidavits. That's in the record appendix. It's also something I delineated in my Rule 59E motion, which I filed post-judgment, where we went through and walked the court through the charges and said, this is what's wrong. These invoices were never served, therefore they can't come back now and say, you owe this additional amount. We also delineated amounts that were altered after the fact. And we delineated legal fees where, there's 3 actions going on with this property. Turk and Quijano, unfortunately, has been commingling legal expenses between the 3 accounts, and I delineated areas on the invoices in my 59E motion where that's clear, where time that's spent on the other actions is being billed to these collections actions, and I'm out of time.
Yes. So
I've got to ask one more question.
Go ahead, Justice Massing, please.
Part of your claim is that the trustees, while billing you the special assessment, didn't pay their own until April, it looks like, of the following year. But there's also a couple of checks in here dated 1/12/17. This is Record Appendix 5, pages 275 and 276, that appear to be those assessment checks. And I guess is your claim that those are backdated or fraudulent or something?
Yes. So in my counter motion for sanctions, which I filed with the court and the court did not take any action on, I provided the court with bank deposit records for the trust's bank accounts. And I also provided the court with a cash and disbursements report that a CPA that we retained put together based on those bank records. And what you will see is that in all of 2017, there was never a deposit from units 2, 4, 5, and 6, the other units, for this special assessment. In fact, that deposit wasn't made until 10 days before the hearing on summary judgment against our units. There is a deposit for $97,986 in April 2018, just prior to the hearing on summary judgment against us, for the trustees' share of that special assessment. That's 18 months later from when it was supposed to be paid. They never filed actions against themselves. What they did was they backdated the checks and deposited that. They wrote 2017 on the check itself, but deposited it in 2018 because they knew we had already raised that in our oppositions to summary judgment. And those are bank records and CPA report that the court had before it when it chose to enter summary judgment against us.
Thank you.
Okay, so Ms. Burgess, we're going to next hear from you, and I'm going to ask Ms. Crispin to unmute. And Ms. Burgess, you have 2 minutes.
Señora, tiene 2 minutos.
Okay. So when you start talking, the clock will come up.
Cuando usted comience a hablar, podrá ver el reloj.
She can put down the phone for this 2 minutes.
Yes. When you're ready.
Cuando esté lista.
Yes. Okay.
Ms. Burgess, it's your turn to tell us what you want us to know about your case.
Señora Vergés, es su turno. Díganos lo que nos quiera decir con respecto a su caso.
Mi nombre es Carmen Berger.
My name is Carmen Burgess and I am an
Soy dueña
owner.
del apartamento número 3 o condominio del Día de la Forestría en Ceylon.
I am a owner of apartment 3 in the condominiums located in Salem, 10 Porter Street.
Lo que los trustees Marco Donahue y su abogado Jeffrey Grant han hecho en contra de nosotras
What Mr. Hill and his attorney, Mr. Grant, have done against us
es un fraude, un hostigamiento, un abuso, una negligencia y una conspiración criminal en contra de Elizabeth CERDA y yo, Carmen Berger.
What they have done, it is fraudulent, it is harassment, it is abuse, it is negligent, and it's a criminal conspiracy against Elizabeth and I.
Para quitarnos nuestros apartamentos.
It is being done to take away our apartments.
Ellos no pagan los condos por 3 meses cuando compraron las unidades. Los condo fees por 3 meses.
They did not pay the condo fees for 3 months when they bought their units.
Y no se le pusieron cargos, ni multas, ni le han puesto una demanda en la corte para quitarle los apartamentos.
And there have been no fines. There have been no suits in the court, no lawsuits in the courts to take away their apartments.
Pero sí han puesto uno en contra de nosotros y ellos violan todas las reglas del edificio.
However, they have come against us and they do break all of the laws of the building, all of the rules.
Y nunca le han puesto ningún cargo ni multa. Y el abogado es abogado de la asociación, no solamente de ellos.
And they have never charged any fines. That is the attorney of the foundation, not only their attorney.
Ms. Burgess, you are out of time, but I want to make sure that there are no questions from Justice Massing or Justice Neyman. Any questions for Ms. Burgess?
Señora Vergés, se le acabó el tiempo, pero quiero asegurarme que el juez Massing o el juez Neyman no tengan preguntas. ¿Estos jueces tienen preguntas?
No, I understand, Ms. Burgess.
No, I understand your argument as well. Thank you.
No, yo entiendo su argumento y yo también lo entiendo. Gracias.
So
Okay.
now we're going to go back to the telephone, Ms. Burgess, so that Ms. Crispin can translate Mr. Turk's presentation.
Ahora vamos a regresar a utilizar el teléfono para que podamos interpretarle la presentación del señor Turk.
And Madam Interpreter, if you need us to slow down, just let us know.
Thank you, Your Honor.
So Mr. Turk, just pace yourself, but when you start, the clock will start.
Thank you, Your Honors, and may it please the court, my name is Jeffrey Turk, and I represent the trustees of the 10 Porter Square Condominium Trust. Your Honors, I would suggest this is nothing more than a prototypical condominium lien enforcement case. The material facts at issue were undisputed, that the plaintiffs are the trustees of this 6-unit condominium. The defendants are unit owners. The association issued assessments both for monthly common charges, but also for special assessments as they are authorized to do for an increase in insurance resulting from the prior lawsuits filed by these defendants for common area repairs, which were necessarily found by the trustees, and for the very attorney's fees incurred by the association as a result of the prior lawsuits filed again by these defendants, and for the attorney's fees sought in this action.
Mr. Turk,
Likewise
I'm sorry to interrupt, but can I ask sort of an overarching question?
Yes, Your Honor.
Start with this. Are there any published cases? I've seen one unpublished case, but are there any published cases in Massachusetts which address the situation where a condo owner simply cannot pay a fee or assessment? And going further, assumes such fee or assessment is either illegal or at least is certainly subject to a material factual dispute. Is there any case law on point that can help us address that situation?
Your Honor, there is no case law that has ever found such an exception to the statute. In fact, the case law has been clear that there is no such exception. Even in Blood, the court said if, did not say there was an exception, said if there was an exception, it would be an extraordinary case. And I believe, Your Honor, this is the prototypical case of not an extraordinary case in which you simply have unit owners of a small condominium who have refused to pay despite the clear guidance issued in Blood that you may not withhold for any reason your condominium charges. And I believe that is for the reason repeatedly stated by this court that such a system would completely usurp the entire purpose of a condominium.
So let me just change the hypothetical slightly. Let's say someone owns a condominium worth $100,000, a unit, okay? Let's say they are assessed $350,000 and there is no way they can pay it. What remedy would they have in light of the inability to pay? Is the sole remedy to seek preliminary or emergency, equitable or injunctive relief, to run into court and leave it to the trial judge to make that determination?
That is, the sole remedy would be to seek an injunction authorizing you not to pay the condominium fees. But again, I think the reason there have been no such cases is because, again, this would be no different than a taxpayer saying, I don't think it's fair, I have to pay this assessment for a school I don't want to use, or I think the mayor is being unfair to me in making these assessments, or I don't want to repair the road outside my house, or I don't want to pay because they didn't fix the pothole. Such a system would completely destroy the entire concept of a condominium.
Go back to the hypothetical I gave. Would a judge, let's say in the Superior Court, have had the discretion to grant that preliminary injunction motion in the scenario I gave you, in that hypothetical?
You know, I do not believe so because, again, the case law is clear. There's no reasonable likelihood of success on the merits. And we go back to Blood. Blood was a completely illegal assessment.
Then what
There's
is
been
meant,
other cases.
Then what is meant in Blood by the words absent a prior judicial determination? Then that must contemplate that a judge does have authority to do something, right?
Your Honor, I think what the judge has the authority to do is if the person tenders the payment to then proceed with a judicial determination, but not to simply say to a unit owner, you can withhold your condominium charges because of your perceived wrong.
Would a judge have a power at the preliminary injunction stage to stay the payment and perhaps have a speedy trial on the issue?
Your Honor, again, I don't believe so because, again, the statute is clear. You cannot offset or withhold your common charges. And the legislature made a clear determination when it amended the statute to add that this was necessary to create the systems of condominium authorized by statute. And a condominium is a statutory creation. And that was the determination, the same as a taxpayer cannot withhold assessments.
So part of the rationale for that is that the condo association needs the stream of income to keep the condo going. Doesn't it sort of take the wind out of your sails though, when the other units aren't paying the same assessment?
So first of all, Your Honor, I have to contest that fact because in the record is the check showing that the monies were paid. Ms. CERDA can argue when it was paid, whether the check, whatever, but it's uncontested that these other unit owners have paid.
When?
Second of all, Your Honor.
When?
Your Honor, the record reflects the check was written when it is dated, was deposited by the management company later, but the check was written when it was written, and other than conjecture or speculation, Ms. CERDA has nothing to suggest that that check was backdated. But I don't think, Your Honor, I don't think that is a material.
Do you agree that the deposit slip that shows the $97,000 on April 10th, 2018 was those checks?
That is when the management company deposited those checks into the account. But again, Your Honor, I don't think the statute or the case law takes into account they didn't do it, so I shouldn't have to do it defense. No one has the right to offset or deduct. And if the court starts to get into looking at, did every other unit owner pay it in a large condominium, who paid what and when, again, the statute is clear. It's not a defense to a collection action, and it would be sending a dangerous precedent to suggest that we're going to start looking at, I guess what I call the two wrongs make a right defense. But again, Your Honor, I think even the facts here are clear that the money was paid. And I think, you know, again, I think the case law is clear that you don't go beyond that. Ms. CERDA didn't contest that there were assessments. Ms. Burgess didn't contest the assessment either in the statement of material facts or even at the hearing. The judge asked her, do you contest that these assessments were levied? And she said, no, we don't contest. But even in their reply brief, their defense is asserted wrongs, perceived wrongs, not any legal matter that is properly before the court. I also just want to, I think it's important also to know, Your Honor, that even if there was some extraordinary defense here, and again, there's been no case that said that, and the Blood case said if, didn't say there is, if there is, this could not possibly be the case when you look at the fact that, number one, and I have to correct Ms. CERDA respectfully, the prior case brought by Ms. CERDA and Ms. Burgess, which was only the latest in a series of cases, was not against the prior trustees. It was against the prior trustees, and then almost the day that these new unit owners became trustees, they bought these units. She amended the complaint to name these same trustees. So it was a suit that was brought against these same trustees, asserting these same wrongs, these same perceived wrongs. And we actually have a decision now, as the court is aware. You not only have the trial court decision in favor of the trustees, but this court has now affirmed that judgment in favor of the trustees, showing that there is no merit to these claims.
Well, actually, no, it doesn't show that judgment doesn't talk about the merits at all. It's based on sanctions for lack of cooperation with discovery.
Well, but Your Honor, it is a judgment. It is a judgment on the merits. It's a final judgment, and I would suggest that it is relative to the merits, because if you look at that, Your Honor, it's a judgment on the merits. But it also just seems to support the fact that these are just bold assertions that have never, when it came time to provide the proof, there's never been any basis for that. But likewise, Your Honor, I want to know what these assessments were for, right? These assessments were not for something like towels or linens, as in the Blood case, which was clearly illegal. We have an assessment for an increase in insurance. And when Ms. CERDA says, well, it doesn't matter, someone's paying the increase in insurance. These other unit owners had to pay it because she didn't pay it. These are for repairs to the common areas, a basic obligation of trustees to make repairs. They got estimates to make repairs. Ms. CERDA and Burgess don't agree with that, so they just refuse to pay. And the assessment is for the legal fees associated with the action that they brought and failed to prevail on. So these aren't some strange, $300,000 assessments for a new tennis court being assessed to them, or some strange, pool that we're assessing them to put in. These are for the very expenses that they caused, and now they object to paying their share of, placing the burden on these other unit owners who have had to pay that amount. So I think even if the court were to look for some extraordinary circumstances, you have a judgment saying they have no such claim, and these are not such unique assessments. These are the normal assessments relating to operating a condominium. And I would suggest that where you have a 6-unit condominium, this is even more difficult because you don't have the other units to spread this out over like a large condominium.
Could you explain the penalties for the cameras? What's that about? That seems like that's $25 a day. That seems like there's thousands and thousands of dollars of that. What's that about?
Well, it is, Your Honor, because they were issued a notice that they had installed cameras in the common areas and they needed to remove them. They made the election of, rather than seeking judicial determination of whether or not those cameras were properly placed in the common areas to which they have an exclusive use, they decided to refuse to remove them, despite being notified of fines that would be levied on a daily basis. The condominium statute, section 10 of chapter 183A, authorizes the trustees to impose fines for violations of the condominium documents. This is a problem of their own making. They had a remedy, which would have been.
Again, they do contest them, but you say, well, you got to pay them first and then you can contest them.
You either have to pay them, or you can stop violating the documents or seek a judicial determination that the cameras in the common areas are permitted. I think the condominium documents are absolutely clear that even though the balconies are common areas to which a unit owner has exclusive use, the documents say no devices of any kind may be placed in the common areas. But these defendants were issued a notice that to remove them, they refused. They were told that they would be fined if they failed to remove them. They refused, and therefore the assessments occurred, which they don't contest that these assessments were made. Their remedy would have been to remove them and seek a judicial determination. Instead, they, again, for lack of a better word, thumbed their nose at the trustees, and that's exactly what you can't do. Again, otherwise, and this is why the statute authorizes fines, otherwise unit owners could do whatever they wanted without any remedy and could continue to violate the documents by doing whatever they want. And the trustees would have no authority to ensure for the other unit owners that their rights under the bylaws and the master deed and declaration of trust are enforced. So unfortunately, Ms. CERDA and Ms. Burgess took the position that we will not remove the cameras, we will not seek a judicial determination, and we simply will refuse to pay an assessment, which is, I guess, what they can do. But Blood makes clear there's a remedy for that, and it doesn't matter the amount. I would note to the court in Blood, in the end, the only thing that was found was legal fees, which far was less than the amount of the amount in controversy, and yet that resulted in the foreclosure on the unit because it was the massive attorney's fees that were incurred in the case at the end of it. So again, Your Honor.
Mr. Turk, I have one final question before time is up, and that is.
Yes, sir.
I know you say that Blood says if there is such thing as extraordinary circumstances. I want you to assume that there is such a thing. What, in your view, would be an example of extraordinary circumstances enabling a party to forego payment first, assuming they had inability to pay? What would be an example? Could you help us out with something conceptual?
Well, Your Honor, in my 30 years of representing condominium associations, I haven't seen the court find one yet. But the only example I could give the court would be and again, this would be theoretical. The condominium installs a new swimming pool in the common areas and assesses that to a unit owner. Clearly a betterment, clearly not permitted by the statute, clearly not appropriate. I guess that would be extraordinary, but again, Your Honor, I don't even know that that would be, because again, you need to go to court to get a determination and you need to pay it. Otherwise, if we say just on perceived wrongs, you can decide this is that extraordinary case, seek an injunction, lose repeatedly, and force an association to take these steps. It would destroy the entire purpose of a condominium,
I understand your
as
argument.
I've stated.
You are out of time. Do either of my colleagues have any additional questions? Seeing none,
Thank you, Your Honors.
the hearing is concluded and we will take the matter under advisement. I thank all of the parties in council, and my special thanks to our Spanish interpreter, Carla Crispin. Thank you so very much.